stops, no one knows. We're going
Hello, everybody. I want to welcome my lovely guest, Jennifer from Crime Curious. You guys should all know who she is. She did the bedtime reading of the Frank's Memorandum, which we were very, very thankful for. And then I am honored to have Chris Welch, who's an attorney who actually was helping us a lot when we were covering the Letitia Stout case, who the stepmom who killed her 11-year-old stepson, Gannon Stout. So I'm happy to have him back and being able to talk to him about all the happenings in Delphi. And I won't be able to say hi to everybody individually, but I'm so grateful that you are all here. And I'm going to let Chris take the floor and tell you guys a little bit about himself.
Hi, everybody. For people that don't know me, my name is Chris Welch. I'm an attorney here in Colorado Springs. I primarily focus on defense, but I also do personal injury. I work now for the Bussey Law Firm, which is a very prominent firm in Colorado Springs. Prior to this job, in my last private job, I worked as a long-time public defender, both in the state of Iowa and here in Colorado. I've tried a lot of big high-profile cases, especially murder cases. I think at last count, I've done a little bit over 20 first-degree murder cases, as well as every case that you can imagine. So I'm excited to come on the show. I'm excited to talk about a different case, and I'm excited to see everybody in the chat and meet as many people as I can. Hopefully, kind of as this goes, I learn more about everybody that's in the chat and more about the case.
We're very excited to have you and have your expertise, and I'm very excited to have Crime Curious back live. It's been a long time, so I know the chat's going to end up having 1,000 questions. So you guys, I know you guys are going to have questions for Chris, and probably not me so much, maybe Jennifer too, but I kind of just want to start. Most people in the chat obviously know the Delphi case itself, but I want to start with just kind of getting your thoughts on, well, I want to backdate a little bit. So on just the Frank's Memorandum or anything leading up to the Frank's Memorandum that you have some opinions on.
I mean, it's interesting because, you know, I was a public defender for a long time. When you're a public defender, you know, there's a difference between what we call public defenders in Indiana and public defenders in Colorado or in Iowa or in other states. In those states, in Iowa or Colorado, you're a public defender, meaning you work for the government. And as a government employee, as a state employee, you're very limited in terms of pretrial publicity, in terms of talking to the media, in terms of trying the case in the media. Indiana's a little bit different. And from what I can tell, just from doing the research and listening to podcasts on this case, what they call public defenders are actually private attorneys. And those private attorneys are basically, they have a contract with the state of Indiana. So they don't necessarily have some of the rules that we had that were very stringent. When I look at this Frank's motion, I mean, I know that everybody in this chat is probably familiar with what a Frank's motion is. So if people have questions on that, feel free to shoot it in the chat. But in general, you know, what I see out of this Frank's motion and what strikes me the most is they're trying to get the upper hand on trying this case in the media. You know, when you file a Frank's motion, or when I file a Frank's motion, I'm really trying to attack the legality of a search warrant or a warrant in general. It's basically trying to traverse the search warrant, meaning you're trying to get rid of the search warrant. You're trying to say that they didn't have enough information and that there are lies in that search warrant. In this case, it's interesting because I think the thing that strikes me the most is they're putting as much stuff in there as possible that they know that I think the media will pick up on. so that they can kind of flip the narrative early in this case. And I guess that's what strikes me the most. I don't know if anybody else has had that feeling, but to me, it seems like they're basically using this as a shorthand way to try the case to the media, to try the case to podcast, to true crime, to get as many facts out there so that it's difficult to get a fair trial or to have an unbiased veneer of jurors should this go to a jury trial.
So you think that putting the Franks motion out would essentially kind of get the details of the case to a wider population, including where the veneer is in Allen County, and then it would be tried so they wouldn't be able to get a fair trial even in Allen County?
I mean, I think there's probably two speculative reasons that they did this. I mean, maybe they are actually trying to challenge the search warrant. But another just kind of conjecture that I have is I could see them doing this because they either want to blow the panel and potentially cause a mistrial or make it difficult for the prosecutors to get a fair trial in that county, or two, they're trying to angle for a plea deal. And the prosecutor may determine it's really difficult for us to get a fair trial, to get a fair jury. I mean, who in the state of Indiana, who in the Midwest at this point, probably has not heard at least some facts about this Frank memo? When I was talking to my boss tonight, Tim, we were talking about other cases, and I brought up the fact that I was going on this YouTube channel tonight, and he knew everything about this. And again, we're in Colorado Springs, Colorado. We're nowhere near Delphi, Indiana. We're nowhere near the crime scene. We're nowhere near places that they'd be picking the jury panel from. And so, again, it's going to be very difficult to get people that aren't going to be familiar with these facts. And again, I think you have to start thinking about kind of moving forward, what's going to be admissible at a trial and what's not going to be admissible at a trial. And in this Franks motion, they can post everything. They can public everything. In an actual trial, a lot of the stuff that comes up in that Franks motion is not going to be something that's potentially admissible, or it's going to be highly objectionable.
Okay, so if they have these named people that they've put into this Franks motion, would they necessarily be able to call those people as witnesses and say, hey, what would they use it for then?
I mean, they can try at the Franks hearing. I mean, the problem is going to be a lot of these witnesses are probably going to object. They're going to file what's called a motion to quash the warrant. They're going to object through attorneys and say that it's speculative or it doesn't go to the probable cause behind the warrant. But ultimately at the trial, the judge is going to determine what evidence is admissible or not, and the judge is going to determine what witnesses are cumulative, what witnesses are speculative. Again, if I'm the defense and I'm subpoenaing witnesses to be there, they have the right to say, I want to quash this subpoena. I shouldn't have to come. The stuff that I'm going to testify is speculative. The stuff that I'm going to have to testify is not relevant at all to the case. The judge is going to have to determine the relevancy. The other thing that I think that is extremely relevant in what's going on right now in this case is, are the new defense attorneys going to run with this same motion? I mean, that's going to be the biggest thing moving forward, because we know what's happened this week, and I don't want to get too far ahead of you. But if I'm a defense attorney coming into this case, I've got to review the evidence first, and I've got the right to run my own defense, and I've got to figure out if this is a motion that I want to withdraw or a motion that I want to go forward with.
Okay, so quick question from the chat. If a person's called for jury duty during this trial, would one of the questions be asked of them, like, have you read or heard of the Franks motion? And if they had, they could be disqualified as a juror?
Yeah, I mean, I would, as a defense attorney, I would ask that they be disqualified. And I would hope that in a big case like this, before somebody even gets that jury summons, they're sending out questionnaires to potential jurors to figure out what people in the public know about this case, especially that Franks motion, especially any other evidence that's not going to be admissible at a trial. But if I'm doing jury selection as a defense attorney or as a prosecutor, I'm going to ask, what have you heard in the media? Did you read this Franks motion? Did you listen to any podcast that went into detail about the Franks motion? What do you know? And then I'd be saying that they have information that's not going to be admissible in court, and so they should be struck. and I should not have to use a preemptory challenge on them.
Okay, so I want to back up just a second. So you were saying that they could potentially call those people as witnesses during the Franks motion. Would those people still be able to quash a subpoena to go to that hearing?
They would file, so they would get, a summons, or they would get some sort of subpoena to appear at the Franks motion. If they have an attorney, a lot of the law enforcement are going to have, a county attorney or some attorney that represents the law enforcement community. And those attorneys are probably going to try to quash the warrant. The judge ultimately would decide whether or not the warrant should be quashed, meaning the warrant or the subpoena should be quashed, meaning, they wouldn't have to come and testify at that hearing. That's all probably going to be pre-litigated before that Franks hearing. Who should have to testify, whose subpoena should be honored. If there are defense attorneys that are filing motions to quash the subpoena on behalf of their clients, all of that's probably going to be litigated in advance of the Franks hearing.
Okay, and does that only pertain to like the law enforcement that's named in the Franks motion, or what about like the civilians?
The civilians have every right as well. You get a subpoena and you're a member of the public, and the first thing that it's going to say on the subpoena is that you have the right to challenge this subpoena. And so what you could do is, you could, through an attorney or even on your own, I can't tell you how many cases I have where we send out a subpoena. Somebody gets the subpoena. They say, I don't have any information about this case, or I have a doctor's appointment that day, or, your classic like domestic violence type situation. I don't want to testify against my husband or wife. And so what they do is they write a letter to the court that says, I don't think this subpoena should be honored. I'd ask to quash this subpoena for whatever reason, or the information is privileged, or it's speculative, or it's not covered. I think before we even get to this Franks hearing, what you're going to see is a lot of litigation about whether or not members of law enforcement and the civilians should actually have to testify.
Okay. All right. So now I have to ask you what you thought about the contents of the Franks motion.
Again, it's interesting. It's speculative. It's interesting. I think it paints a pretty good defense. And again, a part of me thinks this is a really brilliant move by the defense because they've changed the narrative. I've got, and one of the things that Tim printed off for me tonight is I've got the probable cause affidavit. And this probable cause affidavit, to me, doesn't tell us much information. And really what we see as members of the public in cases like this is the probable cause affidavit, right? Everything else is usually kept under seal. All the evidence that is known or unknown in the case is really, really held back until the trial. And the defense here made kind of a strategic decision by kind of putting the information in the cold out there, by putting information about, this white supremacist cult, and kind of created a narrative that makes your mind start thinking, well, that could be right. Could one person have done this? We've heard about some of the crime scene photos, and we've heard about the staging, and we've heard about, the blood analysis. And I know that other podcasts and other YouTube channels have had people on that are much more scientifically based than I am to talk about, the likelihood of one person being able to do this, or the blood spatter that's on the tree. But again, putting that all out there in advance of the trial, I think is really a strategic decision on behalf of the defense, because they're making us all think about something other than just the minuscule details that we get in this probable cause affidavit.
Well, wouldn't they want to put it out if they feel that there is some form of corruption or something along those lines, where this would end up buried because they would end up quashing all of the subpoenas for these types of witnesses? This Franks motion is, or Franks hearing in general could end up just being null and void by Judge Gohl. And then none of that gets told to anybody. It just gets buried along with what they believe is an innocent, client.
Mm-hmm. It's interesting because they're laying out all the deficiencies in this investigation, which I think in this type of a case, you've almost got to do in the public sphere, because as you said, you're exactly 100% right. And some of the people in the comments are saying some of the same things. MJ says a whole lot of sketchiness with this case. I mean, I agree. You know, a lot of times when evidence isn't released, when it's involving law enforcement, it's difficult because if we believe the defense, which again, I don't know that even have enough information yet, or I'm involved enough in this case to say one way or another which side I'm leaning towards. But if we believe the defense, this corruption goes all the way to the top, and we probably need a new judge, we need new prosecutors, we probably need this case moved somewhere far away from this jurisdiction in Indiana, potentially even moved into federal court. And so, you know, again, they've got to put as much out there as possible to preserve the record. And I talked a lot about this in the last case that I covered. And for people not familiar, one of the reasons that defense attorneys are filing so much stuff is because they're trying to make a record. And they're trying to make a record in a big case like this, because if he's convicted, if Richard Allen is convicted, right, there will be all kinds of appeals. There'll be post-convictions. All of these stuff will be raised, and you want to raise all the things that the judge did wrong, all the things that are wrong with the investigation, all the reasons why this case should have been more in the public and less should have been suppressed to the public eye. And in order to do that, you have to file motions like this, and you have to get as much out there as you can.
Well,
Okay, so a question from
the opposite effect.
Oh, go ahead, sorry.
It seems like it had the opposite effect. It seems like, you know, since they put that memorandum out for the Franks motion and hearing, they've begun to seal even more things. I mean, do we have access yet to Richard Allen's letter to the judge about his attorneys? I mean, it was my understanding that any correspondence from the defendant directly to the judge is basically just instantly public record and needs to be posted.
We don't have access to it from the court record necessarily. What we have access to it is through the Supreme Court filing that took place a couple of days ago, and they put in to their brief, they put in that letter from Richard Allen to the judge. They put in the emails between the attorneys and the judge, and they put in essentially in their biggest document, they dumped every motion that's no longer on record.
See, I haven't seen that yet.
Okay, so a question then for Chris. What do you think of the fact that it's pretty apparent now at this point that law enforcement did lie to the defense team about this Purdue professor? Because they essentially said, we have no idea, we don't remember who it is, we can't find the documents, we don't know, we just don't remember, we'll try to figure it out. And then the day after the memorandum comes out, they happen to know who it is, they're talking to him and have a whole interview. And they say that originally, when they couldn't remember who it was, the Purdue professor said there was no ritualistic, it wasn't Odinism, it wasn't any of that. And then when they have this new interview or conversation with the professor, he's saying, well, yeah, it could be, I can't rule it out, essentially. So what happens there?
I mean, it's shocking, right? I mean, it's, we all have this duty of candor to the court, to the clients. Law enforcement is certainly not bound by the rules of ethics that attorneys are, but prosecutors are. And we've got to be candid with the court. We've got to be candid with opposing counsel. We've certainly seen in other cases how law enforcement doesn't always tell the truth, right? They lie during interrogations. They lie during their investigation to trip people up. In a case like this, that's this big, it's just shocking to me. It's shocking to me that they would mislead or that they would lie. To me, if you have this big of a case, you've got to be as candid as possible. Ultimately, as law enforcement and as prosecutors and as public defenders or defense attorneys, ultimately the final goal is a pursuit of justice. Again, if you're hiding stuff, if you're hiding the ball, if you're lying, that really doesn't fit into the oath that you've sworn the courts, the public, the ability to keep the public safe. Again, the defense is going to investigate all this. They're going to investigate the investigation. They're going to investigate who law enforcement talked to and who law enforcement had on their radar. Because ultimately, the biggest defense when this case does go to trial is likely going to be some sort of alternate defense case, right? It's not going to be self-defense. It's not going to be insanity. It's going to be somebody else did this. There's an alternate suspect, and law enforcement did a crappy investigation. And because they did this crappy investigation, they got the blinders on and got narrowly focused on Richard Allen And because of that, there is reasonable doubt that he is not guilty of these crimes.
So what does it take for a case? Oh, I'm sorry, Tree.
Oh, you're fine. Go ahead. It's hard because I can't see you about to talk. Like normally you can kind of see. So no, you're good. Go ahead.
Yeah, I apologize. I had every intention of going on camera today, but it just didn't work out. Too many things going on. And anyhow, so what does it take for a case to be bumped up to federal court? And if it is bumped to federal court, what does that do for public access?
I think that they would have to look at the levels of the crime, and they'd have to get some sort of federal indictment, or say that the corruption runs so rampant in this community that in order to get a fair trial, it needs to be moved to some adjacent court. I would probably be making the argument at this point, if they lose in the Supreme Court, if they lose in the Supreme Court and if these attorneys are kept off the case, that's going to be probably the next step, is that they ask for the case to be moved. They ask for the judge to be recused. Again, what's really interesting in criminal cases is that the defense or the defendant doesn't necessarily have the right to the counsel of their choosing. So even though he's saying, I'm super happy with these two guys, I want them as my attorneys, we see all the time defense attorneys being replaced. We see defense attorneys leaving or quitting or getting double booked. And so, as a public defender, that was always a problem, because the judges kind of treated us like we were interchangeable. If, I wasn't available because I had a trial in one division, they would pull a different attorney. And if somebody was sick or somebody left the office, then they would bring somebody else in as a second chair. And so what the judge is doing is kind of saying, but I have the right to say who you have as your attorney. And I think that's what's going to be really fascinating moving forward, is that basically without a hearing open to the public, so an in-camera hearing, which basically means a hearing where only her and the attorneys were present, she made some sort of rulings that we'll probably never learn the actual basis for, and then took those attorneys off the case. And again, I think that's probably what the biggest issue over the next few weeks is going to be, because again, it's just going to be interesting to see what the reasoning was. She said like gross misconduct. She said that they were negligent. She threw out all these big words, but in fairness to them, they really didn't get any due process as the defense attorney to say, I disagree with that. Client thinks we're doing a great job. The only time I've really seen attorneys, or I've been removed off a case this close to trial, is for conflicts of interest, where I represent a co-defendant, or somebody in my office represents a witness, or there's just been such a breakdown in communication that it's obvious there's a conflict. And even then, this close to trial, a lot of times in my experience, the judges keep the defense attorneys on because there's an interest in having the same defense attorney. It's so close to trial. They don't want defendants playing games right before trial saying, I broke down in communication with my attorney. So here, what I think is so shocking is that I can't ever remember a murder case where the attorneys were taken off, not necessarily because of a conflict of interest or a breakdown in the relationship with the defendant, but because the judge is making some sort of record off the record that they're grossly negligent or committing misconduct or something to that effect.
Right, with no grievances whatsoever filed with the bar or anything else.
Right.
So I have to ask then, so come up to the October 19th hearing, they go in, they are told on October 12th. Okay, so I have so many questions about this part, so I'm going to kind of go a piece at a time. October 12th, she sends an email to Baldwin and Rosie and the prosecutor, and essentially tells Baldwin and Rosie they cannot work on the case until the hearing on the 19th. They don't know what necessarily the hearing is. She says, I'm going to set a hearing to kind of just discuss what's happening here in these emails. Like, the fact that there was crime scene photos leaked, the fact that somebody involved in the leak, potentially committed suicide because of the leak in the investigation, and just everything happening around that. So they have a general idea. They're going in there. This is what they're going to talk about, but they don't understand. I mean, there's no set agenda, if you will. So on the 12th, they said they're not allowed to work on the case anymore. So then Rosie emails her like, okay, well, can we get an idea of what we're looking to do in the hearing? And she essentially says, come to my chambers, 2 hours or whatever it is before the hearing, and we'll talk about it. Is that even normal? That's why I have a lot of questions in just this part. Is that even normal that she would tell the defense attorneys before a hearing, don't work on the case?
I mean, I've never heard of that. And my boss, Tim Bussey, just stepped into the office, and I don't know, have you ever heard of a situation, and I'm looking off camera for people that are looking now. Have you ever heard of a situation where a judge tells you to stop working on a case until you can have some sort of conflict hearing? I've never heard of anything like that, just for the viewers that are listening.
Never, I haven't heard of it either.
So I think that, that was really strange. And then the fact that, again, this was not a hearing that was open to the public. It was done in her chambers. One of the things that's really interesting that I don't want to miss, let me just go up in the comments here. There's been a lot of comments.
Okay, yeah, go ahead.
But Melissa Cox says, does this give him grounds for appeal? I mean, let me play devil's advocate for a second. If there is a conflict, and if the judge really does believe that these two attorneys are terrible, right? That they're bad attorneys, that they have committed some sort of malpractice, that there's likely going to be ethics complaints coming due to the leaks, or that they are doing something that is just grossly negligent. The problem is going to be that if he's convicted, what's going to happen? He's going to appeal, and he's instantly going to turn on those two attorneys and say, I agree with the judge. You did a terrible job. You leaked photos. You filed this motion that I didn't agree with. The judge wanted to take you off. And so, Melissa Cox, I agree with you. I think that if the judge kept them on, she's in a terrible position, because if she keeps them on, she's basically setting up the grounds for appeal or some sort of a post-conviction relief claim. And that's what's really difficult, is the judge is in a no-win situation. But again, in a situation like this, we don't really know what the judge's rulings are, or what they actually did, or what the judge believed was negligent on their behalf, because she did this in her chambers.
So that's what my next question is can she actually make these rulings in her chambers? Is that a legit way to put things on the record?
I mean, potentially,
is it a legal way to put things on the record?
I don't know. Again, I'm a Colorado attorney, and I was an Iowa attorney before this. And so I'm going off kind of just the commentary that I'm giving on this case and what I've seen in previous cases. And normally, judges have the right to do a written ruling. They have the right to have those kinds of hearings. I think in a case like this, what's so frustrating for people is how highly publicized this case is, and the fact that the two defense attorneys are alleging that she coerced them in order to try to get them to withdraw from the case, right? One of the two is saying, listen, I gave an oral motion to withdraw on the record only because I felt like that was the only option I had and I was coerced. But once I retained an attorney, once a few days passed, that's not what I want to do anymore, Judge. And the other attorney is saying, Judge, you ordered me to file a written withdrawal from the case, meaning that I file it with the court, you grant it, certainly you can do that. And that's normally what we see in terms of these types of hearings where a judge is determining conflicts, at least in Colorado or Iowa, is that, let's say Tim has a case and he feels that like there's a conflict of interest in terms of representing his client. What he's going to do is that he's going to file a motion to withdraw. He's going to ask that it be set for hearing. He's going to give client the right to object. That hearing is going to be held a lot of times outside of the public realm if the client is going to make accusations that you don't want the prosecutor to hear. And then the judge is going to issue some sort of order in terms of whether we should stay on the case or not. And this is just strange because it's all in the judge's accord, and without any written motions being filed and without any real explanations from the judge. Janie Lane, I'm reading your comment as it comes. And again, that's just the difficult thing in this case.
So, okay, wait a minute. You said not in the presence of the prosecutor?
A lot of times we don't. When we do conflict hearings in Colorado, and a lot of times the client is alleging some sort of conflict, a lot of times what you do is you do that hearing outside the presence of the prosecutor. So they're not saying things like, listen, Chris or Tim, they won't listen to me in terms of running self-defense, or they won't listen to me in terms of tracking down these witnesses. And so a lot of times that's why you have those types of hearings outside the presence of the prosecutor. But here it's just really interesting. It's
so the prosecutor was there for this weird meeting.
The prosecutor heard a lot of it. And the other thing that I think was interesting was that there were private attorneys that were representing the two public defenders that were there that were also trying to express their position on whether or not these two attorneys should be taken off the case so close to trial.
Well,
So having this,
also,
go ahead.
oh, sorry, T.
You're
Isn't
fine,
there
honey.
also
Go ahead.
supposed to be a separate judge? I mean, like in Letitia's case, when she had the conflict attorney, that was overseen by William Bain, who's the chief judge in the district. So not only were the prosecutors there, but also it's the same judge. And it's my understanding that with the conflict hearing, neither the judge nor the prosecution are supposed to be privileged to that conversation.
And Jennifer, Tim just said that's a great point. He was just nodding his head. And I agree with you 100%. That you bring up a great point for the viewers that, in Colorado, a lot of times what you have is you have another judge like Judge Bain in her case hear this conflict hearing and determine whether or not the attorney should stay on or not, or whether or not a conflict exists. And what's strange here is that we basically had a judge raise her own conflict and say, I don't believe that either of these attorneys are competent to move forward. They've created all these issues. And so I'm just on my own, without really any sort of hearing or due process, going to take these two attorneys off. And then they come back and say, Judge, we're willing to do this for free. We're willing to do this pro bono. We want to continue with the case. We've filed all these motions. We've done all this work. It's ready for trial in January. And she basically says, too bad, so sad, you're off.
Okay, so I got to back up to this in Chambers hearing where it seems like it would be some type of conflict hearing, and she's supposedly has this prepared statement written that she's telling them, hey, I'm going to either go read this in court and disqualify you publicly in front of everybody, or you guys can essentially walk away. And that's according to the defense attorney. Since we haven't actually heard it, that's all we really know right now. But no matter what, with all of that happening, why wouldn't Richard Allen? He's right there in the courthouse. Why would none of that happen in front of him?
And that's the other strange thing. I mean, Tim, just to bring you up to speed, and Tim again is off behind my computer. Defendant's not even here for any of this. He's not even brought over to the courthouse for these conversations. And again, to me, that seems unusual. Usually in cases that are this big, when I was a public defender and I was trying murder cases, again, I wanted the defendant to be present for important decisions in his case. And an important decision like removing me from the case seems like something that should be done with him present so that he can hear, so that he knows what the rulings are, so that he can say that he was fully advised by the judge, so that he can make a competent decision. And right then and there on the spot, instead of writing a public letter to the court and to the Supreme Court, he can say, look, I want these attorneys. I want them on. I understand that there may be a conflict. I'm potentially waiving that conflict because I want my choice of these two attorneys. And so, again, I think that's strange. I think there's a lot of things that are strange, but I don't want to offend anybody living in Indiana, but maybe it's just the way that Indiana works. Maybe their court system, again, true crime is kind of a new genre, and following these big cases is kind of a new genre. And maybe this is the way that they've been doing things for a long time. And because there hasn't been a public eye on a state like that and on a courtroom like this and on big cases like this, maybe this is the way that it's been done. And they're going to be told real quickly, you're violating people's constitutional rights, or you're not doing this right. But again, I don't know. Melissa Cox again comments and says, I live in Indiana and Indiana is backwards. Again, I've never practiced in Indiana. I practiced close by in Iowa, but it was a very different experience.
So he was in the courthouse. He was just in the other room. They could have made sure that everything was done in front of him. It just wasn't. And I don't understand what the purpose would be. So there's a, obviously, that there's a lot of podcasts. So there's, defense attorneys that do podcasts, there's prosecutors that do podcasts, and there's a bit of a situation where they don't agree and they think that the prosecutor's side of things is essentially saying Judge Gold almost did them a favor. She didn't want to embarrass them in front of everybody, so she gave them an out and they took it. Now, if there is nothing, there's no motions to withdraw, there's nothing filed saying that they're actually withdrawn, how are they withdrawn?
I mean, the judge has made an order now that, you know, again,
Now, but then I don't understand.
I mean, I think part of her order was that, you know, one attorney withdrew orally, which, you know, certainly he can make an oral motion and she can accept that oral motion. And then I think her order was that the other attorney file a motion within 10 days. And when 10 days didn't come, that's when I think that she took this into her own accord. You know, again, she's appointed other attorneys. You know, if I'm going to play devil's advocate again, I played devil's advocate before when I talked about if this case goes to trial and loses, no matter how much, you know, Richard Allen loves these two attorneys and thinks these two attorneys are the greatest thing since sliced bread and they're going to win this case for me. The moment that he gets convicted, those feelings are over. That's what happens in a murder case, you know, or any type of big case, is that at some point they start to harbor resentment against their attorney and they turn into that Monday morning quarterback where they're saying, I would have done this, or he should have done this, or he should have filed this. And the biggest thing that he would have had would have been this conflict. But again, you know, looking at the flip side of things, maybe they have really done some things that we're not aware of. Maybe the judge is furious by this Frank's motion that's been filed. Maybe this judge does believe these two defense attorneys are incompetent or they're doing things that are ultimately going to cause serious harm to their client's case. And maybe she's giving them an out and saying, get off. And I won't read this statement in open court about all the things that I believe you've done wrong, that have created a conflict, that make it so that I don't believe that you can move forward. And so then she appoints the new attorneys. And I guess that's another way to view this and another way that we have to think. And I don't know that we'll ever know the answer unless these two defense attorneys finally say, listen, I'm off. I don't want back on the case. And then they start going on some of these podcasts and they start going on some of these YouTubes and explaining more about what the judge was going to say or what she was going to read or what their thought process was.
There is rumor that the judge has ordered that recording to be released. I haven't seen it documented yet, and I haven't seen it released yet. So that'll be interesting if she does, because, I mean, they're already requesting it, and legally, I don't know how she would really be able to seal that. And if she believes she's in the right, I guess it would be in her benefit to let it out.
Yeah.
So
yeah, I mean,
it takes
certainly.
me. Go ahead. No, I'm sorry. I jumped ahead. Go ahead.
No, I mean, certainly if she releases it, it's going to be interesting. But I mean, if she releases it, you know, again, are the defense attorneys going to fight the release? Are they going to say that it's going to harm our reputation or that it's going to harm the defense? I mean, there are so many interesting factors that have been created just out of this conflict hearing. And, you know, we have to go back to this case. And you think about all the people involved, right? You think about the victims' families. You think about Richard Allen's family. And everybody wants a quick and fair trial. And everybody wants a speedy trial. And one of the questions that came through from See-Through is, you know, what would have happened if he had opted for a speedy trial? Again, you know, the judges want to get these cases to trial. They want to not have delay for the families on either side. And this is frustrating because now we're looking at almost a year. And if that's even a good day, who knows? This new defense team is going to come in. They're going to have to read all the evidence. They're going to have to get caught up. There's probably, what I can imagine, thousands and thousands and thousands of videos and audio and body-worn camera and documents. And after they review all of that, then they're going to have to figure out what experts to hire. And then they're going to have to figure out what defenses to endorse. They're going to have to figure out whether they want to stick with this Frank's motion or they want to challenge other evidence. And so even the date that the judge set right now is probably fluid. It probably could be changed. If I had a big case like this, I would probably be telling defendant, listen, we have to do this right. This is such a big case. It could be years before you go to trial because we want to make sure that we have the best experts in the country looking at this. We want to make sure that we leave no stone unturned in terms of the investigation that the Frank's probable cause affidavit or the Frank's investigation and that motion, you know, put forth to the court. We want to make sure we're doing everything right. And so this is not likely to be a speedy trial, but that's the frustrating thing here, is that this could delay things even further.
Right. And meanwhile,
Okay, so before, yeah, okay, so we have to bring that up too. But before we leave the October 9th thing, I just want to ask, like, so it's clear cut. with if he said, I'm going to put in my document to withdraw, I'll put in my motion to withdraw in writing, and doesn't do it, is he still withdrawn?
I think at this
It's
point
not
they're both withdrawn by order of the court. I think at this
Well, no,
point,
I mean, from that point, though, legally, would he have been withdrawn before the stuff that happened yesterday? Would he have been withdrawn just by saying, I will do it?
I don't think so. I mean, again, I don't know Indiana rules and procedures, and I don't want to give legal advice for a state that I'm not licensed in. But I think that potentially he's got to file either in writing, or he's got to make an oral motion to withdraw, or the judge has to make some sort of ruling that he's withdrawn. So no, I think just saying, Judge, I'm going to file a motion to withdraw. No, you're still on that case until the judge either accepts the motion or the judge on her own accord takes you off the case. You know, a lot of times what we have happen is that we have a difficult client that wants us off the case for one reason or another. We have to continue to represent that client until we have an order from the court appointing someone else. You don't want that client to go without legal representation. You don't want them to not be covered. You don't want the police to then think of that as an opportunity. Hey, this client doesn't have, or this Richard Allen doesn't have attorneys right now. Let's go in and talk to him. So you want to make sure their rights are protected. So no, that attorney's on the case until he gets an order taking him off.
So he submits that he's putting in his verified I'm sticking around motion and says, we want to remove her. Like that, I want a motion to disqualify this judge. And then she puts in there, sorry, who cares? We're going to go ahead and remove all of that from the court record because you withdrew on the 19th, which is why my question for me is important, because I do not feel that he did withdraw on the 19th. And so how she says, sorry, you just don't exist anymore, we can just delete everything off the court record because you're not part of this. Like, I don't get that.
Right. Yeah, that's what I think the Supreme Court's going to have to look at. That's probably creating major issues for Richard Allen's appeals and Richard Allen's post convictions, in terms of the fact that there was confusion and that this judge was basically dictating what happened when this attorney was saying, I'm not off the case, I'm still on, I never filed a motion, and I was coerced, is what he's saying. Okay,
so then they say, okay, we're going to just go pro bono. We're throwing in our pro bono hat. We're going to eat the cost, and we're doing this anyway. And they walk into court and they're like, no, we're the attorneys. We're going to sit at the defense table. And she comes in and she's like, sorry, once again, you don't go here. And then she says, I've disqualified you. How can she disqualify attorneys that don't have a hearing? And then also on the flip side, say, I'm sorry, to these attorneys, you guys withdrew. You guys withdrew and I disqualified you is not the same thing. And then there's no hearing to withdraw and there's no hearing to disqualify.
Yeah.
How do we get there?
I don't know. I mean, that's the $1 million question, right? And again, we don't know. We don't know the answer. We don't know what's going on. It's just that I think alone is going to create a lot of conflict moving forward in terms of, did they withdraw? How did this happen? What happened? I just don't get it at all. And I don't even know the answer, because again, I think they were smart coming in there saying, well, if you're going to appoint someone else, we'll just come in pro bono, because, you know, the way that the system works, just for people that this may be over their head, is that she's appointed these two. The court has appointed these two as the attorneys at state expense. So they're getting paid by the state. So then she says, well, I'm going to appoint two other attorneys, and then they're smart and brilliant and are saying, we'll just do this pro bono under our private license. Like, we'll just pretend like that he's a client that walked into our office. We said, we believe your case, we believe your cause, we're taking your case pro bono. So then they try to enter that way to say, Judge, look, he picked us, he wants us. And she still says, no, you're off. And so again, that creates a thorny issue, because she's trying to appoint other attorneys when he already has the two attorneys. But again, there may be a much bigger conflict that we're not aware of. There might be things that we're going to come out that we're not aware of. But clearly this judge thinks that there is such a conflict that if she goes forward with these two attorneys, that any judgment or any verdict is going to be tainted such that it's going to be a new trial. I
don't know how at this point there wouldn't be, just knowing what we know. And I do want to make it clear, There could be something that we don't know, because she does state a couple of times, like yesterday she states like that she'd been lied to, or that the defense attorneys had lied to her or something like that. Obviously there's no court transcript, so I can only go off of media and what they say happened. And I'm like, okay, we don't know much about this lying thing. There's also commentary that these leaks go back to December, and that this has been something that's continuous. So I do agree. There could be a whole bunch of other things that have happened that we're not aware of and that have created this conflict. But I'm at the point where I feel like she set up the case for appeal no matter what, unless she leaves and another judge comes in and does the disqualifying motion or hearings and makes those decisions and says, no, I'm not biased. I have nothing to do with any of this. Because now she's violated his Sixth Amendment right to counsel of his choice, private counsel of his choice. How does she get around that and not come up with an appeal? I know, this is where I'm at. I'm like, I can't make heads or tails of it. I don't even know if what she's doing is legal at all.
Right. I've never seen anything. I mean, again, I told you before I went on that I had one similar situation when I was in Iowa, where I was right about to try a case, and there was a conflict with a witness, and the client wanted us on, but it was a full-blown hearing, and there were briefs that were filed by both sides as to why we should or shouldn't stay on. And then the client was put under oath, and he made his record about the fact that he wanted us to stay on, and then the judge made a determination over whether or not it was a conflict, and determined it was a conflict, and took us off 2 weeks before trial. And in this situation, it's just so weird, because there's so much that's happening behind the scenes. We don't know how much is potentially corruption. We don't know how much on the other side is because of the fact that she has information that could be really damning against these attorneys, or whether she's basically lost the entire courtroom and lost this case. And it's just turned into, for lack of a better words, I'm sorry to curse on TV or on YouTube, but a shit show. Good. And that's what this is turning into is, you've got all these issues that are being raised. And instead of focusing on, all the issues that are going to go into trying this case in 2 months, it's all these issues about who his attorneys are. And, again, if I'm the new attorneys, I don't know if I feel super comfortable yet reviewing the discovery and billing the state if the client probably doesn't want you. And are these attorneys going to be brought back on? Is this judge going to be replaced? There's a whole lot of stuff that's up in the air yet that I think the Supreme Court probably has to rule on. Other courts potentially have to rule on. And I agree with Jennifer a lot in what my boss Tim said before, that I don't know why they didn't bring in another judge to hear some of this stuff and make determinations and decide whether or not it should be going forward. Yeah, maybe this is all, somebody says in the comments, a Norse pagan heathenry cabal cover up. And I don't know. I mean, nothing lately makes any sense. A lot of times, yeah, let me just say this, because I'm kind of going on a rant right here. But a lot of times in big cases where you have nothing, like in big cases where I am screwed, like I don't know what the defense is going to be, it's kind of create as much chaos and havoc as you can to create as much of a record for your defendant's innocence as you can, or to create as much of a record in terms of these are the mistakes the judge or the DAs or the prosecutors are making. And so, again, it's difficult. Rucus Rocks wants to know, what's the difference between an in-chambers conversation and a sidebar conversation? A sidebar, you go up to the bench. A lot of times in Colorado, they play like white noise, so you can't hear what you're talking about. But there's usually still a court reporter that's sitting up right there typing. Usually in chambers is even more private than that. Usually you don't have a court reporter that follows you into the chambers. The court reporter stays in the courtroom. You go and have your private conversation off the record back in the judge's chambers. Sometimes, like I can remember a couple murder cases in Iowa that I did, a court reporter would come back with us to chambers. But in general, the way that you differentiate is that one is in the open courtroom with just white noise where you approach. The other is back in chambers.
And so if the court reporter was back there, is that where this transcript's coming, or is it just recorded?
It's
like if she's
if it's back in chambers, a lot of times it's not typed up. they may have a recording going. So if she's saying that there was a recording, then maybe there's a recording that's going back there. Maybe they did have a court reporter. But in general, you know, or bench bar conversations are when you approach and it's really quick. In chambers is when you want it to be even more private, and you want to articulate things that you don't want to be in open court, or you don't want people that are observing to hear.
So can you speculate onto why not one single high-profile attorney has shown any interest in defending Allen?
I mean, it's difficult, right? I mean, you think about, you know, this goes back to kind of who I am as a person, right? I was a public defender for a long time, and now I'm in private practice. And it's difficult because there's certainly going to be a lot of publicity with this case, but the amount of effort that it takes to try a murder case, you know, again, if you're going to come in from another state, or you're going to be a high profile attorney that takes this case, you're likely doing it pro bono because of the fact that he's in jail. You know, we have to remember that he's not out, he's not working, he's not making a bunch of money. Whatever savings he has is probably being depleted on, you know, his wife and keeping his life together on the outside. And so there's not going to be a lot of money. And I'm not saying that attorneys take cases only for money. Sometimes attorneys take cases because they believe in the cause. Sometimes attorneys take cases because they want the notoriety. Some attorneys take cases because they believe it will lead to further cases or will further their career. In a case like this, it's going to be so much work. There's going to be experts that you have to hire. There's going to be just mounds and mounds of discovery. You know, you think about just a regular case, like a regular DUI or driving under intoxication, with body-worn camera, just reviewing the discovery usually takes 5 or 6, maybe even 7 hours for one case. And you think about the amount of interviews that are done, this could consume your life. This could consume your practice. And we all have bills. We're all humans. We all have other people that we have to provide for, or rent that's due, or mortgages that are due, or firms that we have to pay for employees. And so this would be a difficult case, I think, for somebody to step in unless they were court appointed. And that's a lot of times why you see court appointed attorneys taking over these big murder cases, because they have the unlimited resources, or potentially even the limited resources that the government offers of court appointed experts, court appointed investigators. If you want to get a psychological evaluation, that's usually done at state expense. Whereas if you're in private practice, you have to pay for all of that out of pocket and then hope that the client at some point reimburses you.
So before I get to Shane's question, so if they're pro bono, everything's coming out of their pocket, all the investigation, all the expert witnesses, all of that, right? Okay.
Yeah, and Janie Lee says these guys offer to go pro bono. Pretty sure it's a cost for them at this point. That's right. I mean, they've done all the work. They've billed the state. They've, you know, 2 months before trial, you know, again, you're kind of in crunch time. You know, we're looking at potentially a little bit over 2 months, but you're in crunch time. But you've got a familiar grasp of the issues. You know all the evidence. You probably know that this case better than anybody else in the entire world. And so it's not going to take a lot for you to get this case through trial. And they probably believe in what they filed. They think this is going to be a great case to defend or litigate, and it's going to be great for their career.
Now, just based on your opinion, do you think them going pro bono means that, and obviously this is pure speculation, means that they believe he's innocent, or do you think that it means more that they just believe they could win?
I mean, there's a big difference when you're a defense attorney between somebody being innocent and the state being able to prove somebody guilty, right? Reasonable doubt is a lot different than somebody is 100% innocent. But, you know, attorneys can believe that somebody's being railroaded. Attorneys can believe that there's a lot more to the story. Attorneys can believe that somebody's constitutional rights are being trampled over, and that if they don't step up in a case, even a case like this, where maybe he is potentially guilty, playing devil's advocate, then the next person that comes along will get railroaded like him, because we're basically turning a blind eye to injustices. And, you know, as a society,
that's how I feel right now.
Yeah, as a society, we want these cases to go smooth. We want people's constitutional rights to be protected, because if he's found guilty, then the system works. And if he's found not guilty, the system potentially worked. We don't want these cases that are muddied up, that are messed up, where there's a lot of appellate issues that drag on, that cost the state of Indiana millions of dollars to litigate in the future. Because frankly, with all these issues that are being raised, it's going to be years before we get a definitive answer. We might get a jury verdict, and if it's guilty, it'll be stuck in appeals and post-convictions for 10, 15, 20 years. You think about the cost of the attorneys, you think about the cost of the litigation, You think about all the costs of bringing him to and from the courthouse, of housing him in prison. Again, these attorneys might even think in their head, Richard Allen's guilty, but I don't want this to happen to the next person that could potentially be innocent. Every state has innocence projects. Every case has wrongful conviction divisions that deal with cases where people are railroaded, where their constitutional rights are trampled on, so that somebody can get a conviction, so that they can tie up for the family a case like this. And then people rot away in prison or jail waiting for their chance to prove their innocence, which for a lot of people never comes.
All right, so Shane's asking, do you believe, so we also hear this, and we were talking about like there's the two sides. So the prosecutors come out and then the defense comes out, on podcasts and YouTube and whatnot. And the prosecutors are like, no, there's always a ton more evidence than what's in the probable cause affidavit. And the defense attorneys are typically like, you're going to put your best info in your PCA that you have available at the time. You're not hiding anything because you want the court to use that. So what are your thoughts on a PCA in general? And then what are your thoughts on this question?
I mean, I've often seen PC affidavits that leave out a lot. I think they I disagree with some of the defense attorneys that are saying you put everything you've got in the PC affidavit. I think the strategy that I've seen is that you put enough in order to bind it over and for the judge to find probable cause, but not to tip off your whole hand. A lot of times you're still doing part of the investigation. You may still be interviewing witnesses. There may be stuff coming in. You may hope for a jailhouse confession. You may hope that he has some sort of cellmate that coerces him into saying something, or not even coerces him, but that he comes out and says, I did this, they've got me. And then you use that against him. You're hoping that potentially he's on the phone in jail saying, to his wife or to kids or anybody else, I did this, they've got me, then they can use that against him. So we don't always see that we don't always see that they put all the evidence in the PC affidavit. And that's not necessarily all the evidence that they're going to have. Clients always say to me, Chris, like, how can they use evidence that's not in this PC affidavit that they use to get probable cause? And again, the evidence is fluid. It can change all the way up until generally right before trial. And then, they'll decide what they want to use and what they don't want to use. I think what we saw, and Jennifer can agree or disagree with this, but I think what we saw in Letitia's PC affidavit shifted wildly between what we saw in the initial PC affidavit and then what we finally saw when the case went to trial.
Oh, absolutely. I use that probable cause affidavit to compare, how I look at every case that we discuss, because it was so different. And I can remember the entire process. I remember exactly how I felt when that affidavit came out. I remember exactly how I felt when those items came out at trial, and just knowing the difference. And it seems like that happens in just about every case. Yeah.
Ruckus or Ruckus Rocks. I like the username.
Yeah, Ruckus Rocks.
I have not. I mean, I've seen some interesting motions filed. I have never filed anything like this. I have not made it through all the 136 pages. And so I'm just going off like what I've read on Reddit, what I've listened to on podcasts and YouTube pages. I probably do at some point need to sit down and read the whole 136 page document. I have never seen anything like that filed. Usually when I see Frank's motions filed, they're like maybe a page or 2 pages or 3 pages, boring legal language, legalese that basically just sets up the issue, and then they have an officer testify at the hearing, and then that's about it.
So I have to take you back to what Jennifer was saying before I interrupted her a minute ago too, about we have to talk about the fact that he's being held in prison and not in a county jail. So is this something that you're aware of happening? Because I can tell you any case I've ever followed, they're not in prison before they're convicted. So I don't know, how common do you think that is?
I mean, I can think of a few cases where for security reasons that I've had clients that have been in prison instead of jail, or if they've got other charges, like if they're serving a prison sentence and then they have a state case. A lot of times you make that decision about whether or not you want your client to either stay in prison or stay in jail. A lot of times, just in my practice, I leave it up to the client, because some people say that prison is a lot easier than jail, than local jail. They have programs, they have classes, they say they have better food, stuff like that. So I kind of leave it up to the client. But here it's a difficult and weird situation because from what I understand, he's basically in prison for security purposes and to avoid, potentially what he's saying is that there's people picking on him, and those people are in law enforcement or potentially jail guards. And so I think that puts a whole nother wrinkle into this case. I think it's also frustrating. I mean, let's look at the flip side, right? Let's put on our defense attorney or family of Richard Allen hat, in that at this point, because of the fact that he's in prison, a place that's reserved for people that have been convicted of crimes, how demoralizing would that be to be sitting in prison thinking they've already made a determination. They can't even put me in the regular jail. They've determined that I'm guilty without even having a trial. Now they're stripping me of my defense. I've been in prison forever, and I had a trial that I thought was going to go in January that potentially would prove my innocence, or at least allow me to move on with my life. And now here I am stuck in a place with a bunch of other people that have been convicted of crimes and sentenced to prison. And I have to wait for my trial. And that's a difficult proposition. And that's got to be extremely hard on his family, extremely hard on his psyche to think about where he's at right now.
Have you seen any time where they say, yeah, your person has to go to prison or has to, wait for trial in prison, even though there is, okay, so Carroll County is where the crime happened, and that sheriff said, no, we should not keep him here. It's not safe for him. So they send him up to Westville Correctional Facility. Another county called Cass County says, we have the ability to take care of him here. It would be fine. Just transfer him here. And so the defense attorneys put that in, and they're like, no, we want him moved. He's deteriorating. His mental health is not getting better. It's getting worse. And we have a spot for him. And then the prosecutor comes in and says, no, we don't want him moved.
Mm-hmm.
That's odd to me.
Yeah. I've never had anything like this. I mean, again, it's that decision alone, I think, has an enormous, moving forward, it's going to be huge in terms of how the case is tried because of the fact he's in prison. I've never seen anything like that. Usually, as I said, my clients that have been moved to prison, it's because of a lack of housing availability in the jails, or they're saying because of how high profile of a case it is, we have to move this person to prison. And then they put them in a separate ward or a separate wing. A lot of times that's litigated before the trial happens, or the person is already in prison for unrelated crimes, and they decide that instead of coming back to jail, I want to stay in prison and wait for my trial. The court has to get a writ, meaning the court has to basically send something to the prison that says, a legal document that says you have to bring this person to and from on these court dates, and then they have to transfer. But it's always a nightmare when the client's not in a jail, because it's a nightmare trying to get into the prison. It's a nightmare trying to go visit them. It's a nightmare trying to prep for a trial, and they may be hours away from you as a defense attorney. Ms. Kay, how do you see how things were filed? Have you ever seen it like this case? I don't know. I haven't looked at the Indiana court system to see if you can just read the filings from the court filings. I'm sure you probably can. Colorado has a system where a lot of times the judges make public certain court records. What I've seen has all been on YouTube channels. It's all been on podcasts. It's all been on people posting stuff to the Reddit threads. And that's a lot of times where I look first. Sometimes you can get public access to court filings, like Colorado, as I said, has the system, but then not all the documents are open to the public. So then you've got to look through all the documents. Letters to the judge are almost always public. Some court filings from defense attorneys are public, some are private. And again, as an attorney, I don't have any special access to court filings unless I'm the attorney in the case.
And so have you ever seen a case where the judge just removes the majority of the court record because she doesn't want it public? It's not filed under seal. Nothing sealed.
Yeah. No, usually the judge
has to do with the crime scene and the autopsies and things like that.
Right. What I've seen is that the judge has to have some sort of legal justification for sealing the records, especially if I'm not asking for it to be sealed. If I file something and it has personal information or case information, or for instance, a birthday or a social security number, I'm asking for it to be sealed. And I'm citing the code sections and the law. A judge has to cite something. They can't just seal it without any justification. And so I haven't seen judges seal stuff without some sort of legal justification.
Well, what if she has a big red stamp in chambers that says "because I said so"? What then, Chris?
I don't know. I mean, it's interesting.
I want one of those.
Yeah.
Yeah.
I want to get one of those. Okay, so have you ever seen a case where the state investigators and the FBI, who they invited to come and help them, disagree on the avenue of who actually committed the crime, and then FBI isn't leads, so you got to go with the investigators? Have you ever seen anything like that?
I kind of have, and I don't want to give away like attorney-client privileged information.
Right.
But in general, in a case like this, you're going to have a field day because you're going to call the people that disagree against each other. You're basically going to use them as adverse witnesses. And what I've done in previous trials where agencies disagree with one another is I've subpoenaed the FBI or I've subpoenaed the state agency that disagrees with the local police and basically put them on and almost qualified them like an expert witness to be like, you don't agree with this suspect, or you don't agree with this investigation, or your investigation led to very different means. And, frankly, Indiana's a lot like Iowa. And I spent 8-9 years as a public defender in Iowa before I moved to Colorado. And people hear those big 3-letter agencies, FBI, CIA, I'm sure Indiana has like an Indiana Bureau of Investigations like Colorado and Iowa does. And they trust those people a lot of times more than they may trust local police because they hear their training, they hear their qualifications. And so when they disagree about who the suspect was, Jackie, what a great way for the defense to say alternate suspect. This case is a case all about alternate suspects, and the fact that the FBI and the fact that Indiana State don't agree on who the suspect is solidifies why there is reasonable doubt in a case like this.
So if you had filed that Frank's memorandum, would you have filed it under seal?
It's hard to say. I mean, I probably would have filed it under seal. But again, I don't disagree. I mean, every attorney is different. And I think I'd be a little bit worried about some of the stuff that they made allegations to. I'd be worried about potential civil ramifications of, if I'm wrong or if I don't have that information and I put it in a motion like that and I file it and it's open to the public, be a little bit worried. But again, maybe that shows that their motion was bulletproof and that they have informants and that they have good information as to why they put all that stuff in there. Most of the motions that I'm filing like that, I'm filing under seal so that I'm kind of surprising the officers at the hearing.
Okay, so you got a lot of questions in here, so I'm gonna go through them real quick. Okay, I think we answered those two. Here we go. If Ellie didn't corroborate RA's alleged confession with facts only murderer knows, is it still admissible? If Ellie didn't corroborate RA's alleged confession with facts. Okay, so like they continue to say they kept all the stuff about the crime scene and everything close to the vest because they didn't want the false confessions that happen in high profile cases, so on and so forth. And then he confesses on the phone to his wife like 5 times in one conversation, and then his mom apparently in another conversation. If he doesn't actually confess using something that he shouldn't have known, would that just be thrown out?
It would still come in. I mean, the defense is certainly going to argue that they should give less weight to that, because in false confession cases, I just tried in 2020 when I was still a public, or I think 2021 when I was still a public defender, I tried one of the very last murder cases that I tried. It was a false confession case. And what I was arguing with the officers was a good confession is when you keep as much to the chest as possible and you try to have them tell you facts that only the person that committed this crime would know. And that's how you can verify, that's how you can tell. And so when you're looking at whether or not this is a false confession or not, you're looking at what facts did law enforcement provide to him without him providing them to law enforcement. So if, for instance, the law enforcement says to him, listen, we've got the murder weapon, it's a gun, it's this caliber, it's this type, and then he's on the phone saying those things, you could argue that's a false confession. They've led him to say what he said. If there's no facts that are alleged, it's easier to then try to either suppress those statements, meaning you try to keep those statements out, or you're arguing to the jury that if the judge allows these statements to come in that are potential quasi confessions, that because he's not saying any information that would corroborate the fact that he's the one that did this, these aren't reliable, and that you should look to the other facts that seem to point to the fact that he didn't do this. The way that you sell that, and just real quick so I don't go on a long tangent here, is the way that you sell that is everybody knows or has heard of a case where somebody has falsely confessed. And we don't know the reason. We can only speculate in every case until we've actually done a deep dive into those cases. But we know false confessions exist. We know that people say things to give other people comfort. We know that the only way to tell if a confession is valid or not is to look at the independent facts that they give in that confession. Is it forced? Is it coerced? Are they saying facts that only the person that committed this crime would know? And if they're not, or if there looks like evidence of coercion, or it looks like there's evidence that they're being forced, then we know that there's potentially a taint on this confession. And in a case like this, that's what you're going to argue if in fact the judge allows it to come in. I don't know about the legality right now, or even under Indiana law, if the defense is going to have ways in which they can try to file a motion to suppress to keep those statements from even being heard by the jury. But that's certainly something that if I had this case, I would allege, I would file, I would litigate pretrial, so that the worst facts are potentially kept out against us as the defense.
Interesting. Okay, well, let me get to the next one. Have you ever heard of correctional officers in prisons being able to wear patches of any sort, any type of representation of their belief system?
I mean, I honestly don't even, I mean, let's play devil's advocate and jump on the other side. They have some sort of freedom of speech. It's difficult. They're government employees. And so I don't know. I don't know the answer to that. I don't know that I've ever seen or ever looked into that issue. I don't know that when I've been at prisons before, I've never noticed whether people are wearing patches that are not work related. I think as a practical matter, and just as a human being that also pretends to be an attorney, I think it's disgusting. I think that that should not be allowed. But then the attorney in me says that some patches are probably covered by First Amendment grounds. Some patches are probably part of groups that they may be involved with as law enforcement professionals or correctional officers. But I have not potentially seen that before.
I agree. And a lot of the like the prison guards and stuff that came in while I was reading through that memorandum and commented, they were like, no, we would never be allowed to have that at all. Yeah. So Ruckus makes a comment, but I actually kind of turned it into a question, because he's stating like she found them to be grossly negligent and that they were committing misconduct, essentially. So he's saying like paid, public defender, pro bono, it's all like a mute point at this time. I guess for me, my problem is where did she find that? Where's that finding at? Like, I get that she can find them that, like if with all the evidence after the hearing, so on and so forth, I get that she could get there, but I don't understand how she did that. How she's saying yesterday, you know, I found you guys to be grossly negligent. When did you find that? And then how do you, on the flip side, once again, say, well, you guys withdrew. You didn't find us grossly negligent if we withdrew. There's no finding of anything. Right.
I mean, again, it's the $1 million question. And I agree, Ruckus. It's just, you know, again, it's a moot point because she's made a determination and a finding. So in her mind, it's over. They can't represent this defendant in any capacity, but where are her findings at?
Right. So, I mean, ultimately, it is a moot point because she just said this is how it is. And until somebody else steps in and says, no, you can't actually do that, she just gets to have her way.
Right.
Okay. Would the defense be making such accusations with regards to law enforcement lying as part of a cover-up, etc., if there was no truth in what they say?
I mean,
like, can you as an attorney just lie and say whatever the hell you want and put it on your memorandum and say, I'm calling them liars, if you know they're not lying?
It's hard. I'm smiling because what I revert to is I've only ever done criminal defense, and now the firm I'm at now does personal injury as well, and we do a lot of personal injury cases and a lot of criminal defense. But when I see like family law filings, that's what makes me laugh, because the attorneys are constantly putting stuff in there and attesting and affirming and saying stuff that I would think that they'd have no business saying. Again, it's a difficult thing to prove. And what evidence are they going off of? Are they going off an investigator? I just don't know. I haven't seen enough of the sworn filings to know whether or not they're swearing affidavits. A lot of times in Colorado, if you're filing a big motion like this, what we would do is file it with an affidavit that says, I'm Chris Welch, I'm awarded, or I'm licensed in this court. This is my affidavit. I attest that all of this is true. And so it would probably prevent me from putting stuff in there that I didn't think were true. But again, in family law filings and other types of law filings, and certainly in criminal court, people are constantly making allegations that may not be able to be provable, but they may be as close to their version of the truth as they believe. And we just don't know what information they've been provided by private investigators that they haven't shared yet. There could be a whole lot more that we just don't know yet.
Hey, T, can you see Kay's comment? This is a question that I'm very interested in the answer to. Yes, that one. Thank you.
Yeah, anybody who puts, if you guys have a question for Chris, just put @Chris, and I'm just going through and starring them so I can bring them up on screen for him to answer. So if you have a question for him, just put @Chris and I'll grab it. So here's Kay's. Chris, how can the judge order the clerk of the court to completely remove filings and motions from the record that were already put through? Not sealing, but completely remove and omit them like they just never existed.
I think that's difficult because I'd be arguing as a defense attorney or even as a prosecutor that we have to have a complete record so that if this case is ever appealed or goes up to the Supreme Court or even goes up to the Supreme Court of the United States, we have a full record of all the filings, all the motions. I hope that there's some way that they are keeping a complete record, but maybe just omitting those from the public's view. Because again, as someone that's litigated a lot of big high profile cases, you want to make a full record and you want to have those transcripts and all those filings sent to the appellate counsel for review in front of the appellate courts, for review in front of the federal courts. I think if there was documents missing, again, if the defense is not objecting and not making a huge stink about it, then they're going to be potentially ineffective because the Court of Appeals at the Supreme Court are going to say any competent defense attorney would have prevented that from happening in order to preserve the record for any potential appeals or post-conviction rights that the defendant may have.
So do you think that in your opinion, then what's now been sent to the Supreme Court, that she's hiding all of these documents essentially from the court record, it's going to be like, no, you need to put everything back and leave it in order?
I think an appellate court is going to tell her that she needs to submit the full transcript of the case, which would be all the motions, all the hearings, even hearings done under seal, all the motions that are under seal, because they're going to have to look at everything.
Okay, so I'm just starring a couple more for you. Let me grab the next one. Okay, so JC Marty. Hey, JC. Is it illegal for a judge to... Oh, there. We just went through that. Same comment. Sorry. Okay, let me grab this next one. Is the defendant brought up to listen on a sidebar?
Not usually. Not usually, Ruckus. In Colorado and Iowa.
Right. Sorry, go ahead.
Usually just the attorney's approach. And they make the short record, and then usually my practice is to then go back and tell the defendant if it is a sidebar, meaning if it's up at the judge's bench. Back in chambers, usually I do want the defendant back there. I would probably have to waive the defendant's presence if we were back in chambers, or make some sort of a record as to the fact that I am waiving their presence. Usually at sidebars, it's just me and the other attorney on the other side.
So I think his point is that it doesn't matter that Richard Allen wasn't in chambers, is kind of like his point of like, what's the difference? Like, lawyers talk to judges on a sidebar all the time. So why can't they talk in chambers and have all the things that happened here on the 19th? Why did Richard Allen need to be there for that? What would that?
Yeah.
What pros and cons would there be?
I don't really see any pros in general on a murder case like this. If there's discussions that are just being held about timing and scheduling and when witnesses are going to be there and when they're not, a lot of times those aren't issues that are big enough to have the defendant there. But any issues that deal with representation, that deal with rights, that deal with waiving stuff, where the judge is going to make a ruling, usually the judges want that person there to hear. And so that's where I have a little bit of confusion in this case, is because they're not having a conversation where they don't need the defendant to be present. They're talking about something that's almost the most important thing to the defendant at this point, your representation, and then your right to have a trial within the next few months. Because if the judge makes this ruling, which she then does, it delays the process of defense that he has, strips some of his attorneys, puts two new attorneys that he doesn't know and doesn't trust on the case. And so, that's difficult. Moving forward from this, can J.C. Marty, we'll go back to other questions, but J.C. Marty says, could the judge be held in contempt? I don't know. I mean, are judges in Indiana above the law? An interesting deep dive into Colorado would probably be to Google what happened with the Supreme Court here, and the fact that they were basically lawless until recently, that they didn't really have anybody governing them. They didn't really have anybody governing the bench in terms of ethics complaints. And so that's something that has been a huge change within the last year or two. But I don't know. I don't know if the judge could be held in contempt if she doesn't return documents. That's certainly an issue that we're probably going to see litigated in the future.
Hold on, let me see.
Hey, T, I hate to do it, but I'm going to have to jump down, and I'm going to join everybody in chat.
Don't go.
I have to. I must. I wouldn't do it otherwise. But I will be in chat, and I will be listening.
Well, do you have anything? Well, say whatever you want to say. Any questions that you had? Because I know that I was trying to just let them ask the questions first, and then. Do you have anything that you want to make sure that you ask before you hop down?
Yeah, a lot of my questions got answered already. It is so confusing. And Chris, I appreciate you so much because, you do have the experience as a public defender and you have the experience as a defense attorney. And not only do you have the ability to go back and forth, but you have this wonderful ability to take us with you while you go back and forth and explain which hat you're wearing when. And I've learned so much from you, and I know that's going to continue to happen. So thank you so much.
Yeah, and thank you. And I don't want to pretend at all like I'm the expert on this case, because I know there are a lot of people in the chat that are probably just as smart as I am and know way more about this case than I do. You have to remember, I'm a busy attorney that has a life outside. I mean, if you follow me on social media, I'm constantly doing the Colorado things. I have a dog at home. I'm kind of in the process of starting this new job here with Tim. Tim was somebody that I really looked up to at my last firm. And I felt like I have a lot to learn yet about criminal defense. I haven't been doing this forever. I've been doing this for about 12, 13 years. And then you hear about attorneys that have been doing this for 30 or 40. And, again, I hope that in 30 years, I'll be doing something vastly different. That's why I'm kind of shifting a little bit more towards personal injury, a little bit easier to sleep at night with some of the cases when you're prosecuting for somebody that's gotten hit by a car or hit on a bike or have an insurance company that's taking advantage of them. But I don't have all the answers, and I'm not, I don't ever pretend to be the most experienced person. And I love all these YouTube channels, especially yours, Jennifer, because I love how knowledgeable and well-versed everybody is. They think through things like me, and a lot of times I may seem like I know everything, but I'm struggling in my head thinking, what the heck, how do I even answer this question? Because this person is so far advanced, Teresa, and everybody else, they know so much more about these cases, and they've thought through angles that I've never thought of. And that's always my biggest fear as a defense attorney, is I'm going to get in front of a jury, and a juror is going to have a better theory of defense or prosecution than either side. And we hear that all the time. We try a big case, and then you talk to the jury afterwards, and they're like, well, why didn't you pin it on this person, or why didn't you focus on this piece of evidence over this piece of evidence? Because to me, it was way more meaningful. And, you have to remember that we're all people in this, and we're all trying to figure things out at the same time. And we only have so many hours in the day to read and digest and figure things out.
Well, my parting words are that I just want to put it on record that I am actively behind the scenes trying to coerce Chris into coming on my channel once a week. And I'm going to slip right out the door with that one.
Is it an ambush?
Right. I'm gone before
we're going to ambush him.
Oh, so you're on my team? Okay, yeah, Chris, you're in trouble.
Absolutely on your team.
Talk to you soon. Bye.
Jen, thank you so much. Okay, so next question is, can Judge Gull punish Rosie for Baldwin's mistakes? And essentially because the leak supposedly, which there's a lot of that's open for interpretation and not really the point of the question, so I won't go there. But the leak came from Baldwin's office. They work in two different law firms. So how does Rosie get disqualified for Baldwin leaving his door unlocked and letting somebody in take pictures?
Yeah, I don't get that either, because it's different if they were actually public defenders and they worked in the same office. But I think in this instance, why can't they just replace one attorney and keep the other? They're both private attorneys. They don't share office space from what I've read. And so I think if there's a conflict to one, it doesn't necessarily mean they're both conflicted off.
Right. So, and I think that kind of plays to is there a bunch of other stuff that they've done that we just aren't aware of because we have no court record to actually look back on, and how many other things have happened? Because she's acting like this is just such a repetitive behavior. She's just tired of it, not just like this one thing. And even in her emails, I mentioned too, like she says all of these recent events, and I'm like, there's only one. It's the leak of photos. So what are like all of these? There's just terminology that's being used that's making me think she thinks there's more, but because there's no hearing and nothing on the record, we just don't know what it is. And so we're like, what are you doing, Judge Gull? All right, so here's your next question. Can a Supreme Court judge step in and handle this on their own? Like, are they allowed to just walk in and be like, I'm taking over and you're done? Well,
I
the
don't
Supreme
think
Court
so.
actually appointed her, so because the very first judge recused himself for fear of bloodlust. For the case, it created too much bloodlust, so he left. So the Supreme Court of Indiana actually appointed her as the special judge in this case. So could they just step in and say, sorry, you got to go?
I think the Supreme Court wouldn't necessarily step in and handle it on their own. They would just potentially appoint another judge or order that a judge from that same district or from a different district or jurisdiction comes in.
Okay. So that once something's filed, essentially, then they can kind of take a look at it and go that way.
Right.
Caesar wants to know if you've ever dealt with a case, and obviously this is going to be more towards like the forensic analysis of items, where a case where there was an unspent round being matched like ballistically. Is that something that you've ever worked with, ever heard of? Because the round they found, that 40 caliber round, was unspent, but they're matching it to his gun because it was ejected but not ever fired.
I think that, gun science is something that I've dealt with before, and I've certainly called experts in gun cases. But I think there's two views. One side views gun science really as a junk science. And, if you go kind of down the rabbit hole in terms of research and you look at unspent rounds and you look at bullet analysis, and you go into some of the science of it, it's difficult to say. I think that that's probably going to be a challenge in terms of how scientific these rulings are. Both sides will have experts in terms of the unspent rounds or the science of it, and the judge will determine what, if anything, can be said at trial based on how scientific those two sides are. I would argue, as a defense attorney, that this type of science is unproven, that it's junk science. The other side's going to argue we have research, we have somebody that's going to come in and testify. And so ultimately it's going to be the trial judge that determines prior to trial whether or not either side can qualify as experts, they're experts, and then allow them to testify about the science behind it.
Okay. And to jump back just a second for the unspent round, to me, I feel like that would just be a battle of experts in the court. Like they're both going to bring in their experts, and it's going to be whoever the jury understands and whoever they like. And that's what I find in any case I ever follow. It's like the expert testimony is it's so overwhelming to a jury. They just kind of go with who they like and what they understood more of. But to jump back just a second, what would make a Supreme Court come in and look at the judge? If that was to happen?
I just don't know, because every state has a different system in terms of judicial discipline, in terms of judicial ethics complaints. I'd have to get back to you on another episode in terms of what Indiana does for judicial discipline. Here we kind of had the Wild Wild West for a while where they really weren't disciplined at all. And so people would make a complaint or make an ethics complaint or make some sort of sexual harassment complaint against the judge, and then nothing really happened. And so I'm not super familiar with Indiana. My understanding is that the civil attorneys have filed some sort of memorandum or brief or filing asking the Supreme Court to look at these rulings. But I don't know that necessarily anybody has filed an ethics complaint against the judge and said she's conflicted off because of the ethics complaint yet, but that may be coming. Or again, that may be something that I've just missed and I'm not familiar with.
No, I have not seen it. So the only thing that we've really seen filed so far was Rosie filing to have her disqualified, where she removed that filing. And then we have the issues that were brought to the Supreme Court, essentially about her not keeping a clean record, even though there's some backdoor comments in there about what's happening with the attorneys. But the actual motion is because of the court record being so dirty for the public. But that's a great point. Yeah, that they technically could go file an ethics complaint on her.
Mm-hmm.
Okay. Can the judge be held in contempt if she's told to return all the documents to the docket or to the case record, and then she just doesn't do it? She just keeps doing it the way she's doing it with no rhyme or reason and nothing in there stating this is why I'm keeping these documents off. What would happen to the judge if she just doesn't listen?
Yeah, I mean, potentially, yeah. If she's an attorney as well, ultimately. And so, they have to follow court orders. And if a higher court says you need to turn over these documents, then, potentially there could be a contempt finding if she doesn't.
To her.
Mm-hmm.
Okay. Can Richard Allen make a demand of his new attorneys, like tell them he wants the whole Odinism defense as his defense? Can he give them like this is how we're going to defend me? Or do the defense attorneys say, no, that's not what we're going to do?
I mean, ultimately, there's a few decisions that are ultimately the client's. It's whether to testify, whether to take a plea, whether to set the case for trial or take that plea. But usually, under the rules of ethics, defense attorneys have wide latitude to decide the defense. And if they feel like this defense is like morally repugnant to them, or it's not something that's supported the evidence, they can try to run another defense. This would probably ultimately set up another conflict hearing where potentially Richard Allen is saying, I have a conflict with my attorneys. I want to run this defense. Again, that's why you would do it outside the presence of the DA or the district attorney or the prosecutor, and why potentially you would want another judge to hear it, because you would not want the trial judge to know what your defense was potentially going to be, even though we all know at this point. You would not want the prosecutor to know what defense you want to run and why the defense attorneys don't want to run it. I've been in conflicts before where a client wants to run, for instance, self-defense. I think the best defense is some other sort of defense. We can't get past that conflict. We have to have a hearing. I articulate to the judge that it's my right to choose the defense. The client has the right to testify, the right to plead, but not the right to necessarily craft every aspect of their defense, including who we do or don't call as witnesses. And usually the judges side with the defense attorney, but if it gets to the point if it gets to the point where it's both sides can't agree and they're saying that it's a conflict, then they go, then the judge will take people off.
Okay. So if he says, I want Odinism, they say, we're not doing that. He says, I'm talking to the judge and going to get myself a new attorney who's going to do what I want. Reminds me of Sarah Boone. I don't know if you're familiar with that case, but she's on like her 7th attorney at this point because they can't agree on anything. Okay, so next one. If the judge is proven to have violated the defendant's rights, would they ever face any serious consequences? The state never seems to hold itself accountable.
I don't know. I mean, it's interesting. I don't know if they would ever be held accountable. I mean, that's, the system a lot of times protects people in power. And so, again, you can go down a rabbit hole of Googling, are judges held accountable? Do they have consequences? And it's hard to say. What we saw, I think it was the Florida case, we saw a judge removed recently that made potentially inappropriate comments at sentencing to the public defenders. I think that was the school shooting case in Florida. And so we have seen judges face consequences. I think in that case, they actually removed the judge shortly after the sentencing. They determined that she did some unethical things. And so it certainly has happened before.
That's interesting. So I'm just like, would she be removed from the bench? Like, would she be just totally?
I don't. Does anybody know? And somebody can put in the comments what happened to that judge. Let me just look. It was like the Parkland judge. She was removed, I think, after the case. Let's see.
The one that just happened?
Yeah, she was. I think she was reprimanded. The Florida Supreme Court reprimanded judge for conduct. And then I think that she just basically resigned because it was a reprimand. She violated several rules governing judicial conduct during last year's trial in her actions toward Cruz's public defenders. The 15-member commission found that she unduly chastised lead public defender, wrongly accused one of his attorneys of threatening her child, and improperly embraced members of the prosecution in the courtroom after the trial's conclusion. The commission, composed of judges, lawyers, and citizens, acknowledged that the worldwide publicity surrounding the case created stress and tension for all participants. Regardless, the commission said judges are expected to ensure due process, order, and decorum, and act with dignity and respect to promote the integrity and impartiality of the judiciary. So again, that's a long way of me reading saying that easily could happen in this case. Do I know? Am I predicting that's going to happen? No. But could it happen? Maybe.
That's interesting. I'm gonna have to look more into that too, because that's Florida, right?
Yeah.
Okay. Let me see what's next. What do you think about the fact that the witnesses, that law enforcement said that the witnesses said one thing, but come deposition and looking at the actual statements, they actually said something else? How much do you think that's going to weigh?
That happens all the time. I mean, criminal cases, people constantly change statements.
So it's not really going to change the outcome of anything at a trial.
No, I mean, it'll be something that both sides will argue, depending on which witnesses it is and whose witnesses they are. You always argue that, you said one thing and said another, but ultimately they're not under oath unless they take depositions prior to the trial or unless they're at the actual trial. I have witnesses change all the time. They talk to an investigator and say one story, then they come to court and said another. And when they come to court, I'm saying, hey, you told my investigator this. And they're like, well, I wasn't under oath, Chris. And so, again, all that really matters is the story that they tell at trial.
That makes sense. Okay. All right. I guess I'll have to take that into consideration, because that really bothers me when it's part of the Frank's memorandum that those witnesses are just the muddy, bloody, but it's just muddy, that they say he's wearing a tan jacket, but he's wearing a blue jacket, all of that. Have you ever seen a Frank's filing on corruption on the investigators and the accused investigators? And the accused investigators end up I know it's a lot of investigating. Have you ever seen a Frank's filing? Basically, the defense team says, hey, these investigators are corrupt, they're lying, they're doing shady stuff to get the probable cause for arrest and search warrant. And now there's this leak of photos, and the people investigating the same defense team who accused them of being liars and scandalous, they're investigating that defense team about the leaked photos. Conflict?
Yeah, it seems like it. It seems like a giant conflict. I mean, again, we only know what we know, and it's just hard to say over which side is right and which side has what. But it seems like, it seems like all sides at this point are potentially raising conflicts, and the defense is saying that potentially the investigators are now conflicted and that they got this search warrant under terms that were maybe not correct.
Yeah, and so now you're going to let those same investigators work on a case that involves the defense attorneys?
Right. And, one of the things I want to be clear on, and I think Marshall Dove says, since when does law enforcement change a witness statement? Normally we hope that if a witness comes to law enforcement or comes to the prosecutor's office and talks to an investigator or the prosecutor, ethically, if they make another statement and they change their story, ethically, at least in Colorado, then the state has to provide that to the defense and has to say, this witness changed their story. They came in, they recanted. All those things are things that are potentially exculpatory, and the defense is entitled to. And so, stories change all the time in criminal cases. People's memories change. They don't. And and I don't want to put you on the spot, Marshall, so I'm sorry if this feels like it's putting you on the spot. But, you know, we hope that ultimately they're not changing their story because they've been intimidated or they don't want the media pressure or they don't want to testify. But ultimately, both sides are entitled to know if witnesses or investigators are changing stories. We want to know when it's exculpatory if law enforcement got two different stories from somebody. They should be releasing that in discovery. That should be litigated. And so, you know, those things are all interesting, and those things happen all the time in criminal cases. And it's extremely interesting when that happens. And as I said, there's multiple reasons beyond just somebody's lying. Somebody, again, might feel intimidated. Their memory may change. They may have been intoxicated at the time. They may not want the pressure of going to trial. They may have been coerced by somebody outside of law enforcement to change the story. And so that's difficult. Crystal Lynn says their words can be used against them on the witness stand, though, right? Yeah, I mean, they can. And I don't know if Indiana has depositions before they do a trial. Depositions, for people that don't know, and I'm sure everybody here knows, so I might be preaching to the choir, but depositions are when you have a witness under oath before trial and they say their story and they say what they're going to testify to. And then if their story changes between the deposition and the trial, you can impeach them. In general, you know, it goes to the credibility of a witness if they're taking the stand and saying things that are different than what they would have said previously, and you can use that against them. You can potentially try to impeach if they were under oath before.
And that's what you would do if the investigators were the ones that were actually lying, right?
Yeah,
you would just try to impeach them on the stand.
Yeah, you would put the people on the stand to say that if you're going to impeach an investigator, you would have the investigator testify first. You would say, isn't this what this person told you? And then when they disagreed or when they said the lie, then you would call the person next to say, that's not what I told that investigator, or my story changed, or something like that.
Okay, so I just want to make sure I'm trying to get it. So, because I know that once we start talking about the question, because they're a little further behind, people start asking more questions about it. So I wanted to make sure that I can kind of wrap it up into one. Let's see. What if there's no chain of custody on the unspent round? So that was one of the things that was claimed in the Franks memorandum, is that there's photos of the bullet, the unspent round, at the crime scene, and then there's no photos of it again until it's at the forensics lab.
Mm-hmm.
Would that be something that, as a defense attorney, you would challenge and say, hey, no chain of custody here. We don't see any other photos. It's got to go.
Absolutely, yeah.
And do you think it would be out?
I don't know.
It would be out.
Probably not with this judge. It would probably come in, but I would argue that it should be kept out. I mean, you have to read your audience, and you know, a lot of times, like, you know, part of being a defense attorney is saying, or an attorney in general, you probably know this from talking to a lot of attorneys, is maybe or probably, and you can never make promises to your clients. Like, you can say, hey, this is what we expect should happen, but then you go in front of a judge and you're like, well, I'm reading the room, and you can kind of tell how a judge is going to rule. So I don't know. I mean, I would argue that, but I could also see it coming in.
That's funny. You're just like, yeah, with this judge, it probably would still be there. And that's neither here nor there, really, because it's probably true. Have you ever had a case where you came in after other attorneys have been thrown out? Have you ever been like the new attorneys in this case?
Yeah, and it's terrible. I mean, it's not fun. I mean, because they've kind of, it's, I don't know. I kind of likened it to, like, if you're dating somebody and then, or somebody is married and then they get divorced and then you start dating them right away. Like, they're kind of still trying to get over their ex, and they've had a certain way that the case has been defended, and it's difficult, right? They have this relationship, and then you're kind of coming in at the 23rd hour, changing everything. And if Richard really wants that defense of, like, the Odinism and all that other stuff, and you disagree with that, that's going to create a conflict and rock the boats right away. And if he really liked those attorneys, that's the same thing. Like, he's got this relationship, he trusts them, he doesn't agree with them being removed. And so those are the challenges. The other challenge is just the time. I mean, I think the longer people stay in custody for these types of cases, the more they give up hope. They don't want to rehash and relive all the stuff that they told the previous attorney. You're sifting through all this evidence. And you're not going to be, as the second attorney, you're not going to have as much leeway in terms of asking for continuances, because at some point the family of these two girls are going to say enough is enough. Like, we've been waiting since 2017 or whenever for a trial. We want justice. We want this to be over with. This is hell. We want finality. And at some point the judge is going to say, you're right. Like, this can't just be pending forever. And so I always feel like when I come in like as a second fiddle to another attorney, it's always like the judges are like, we're not giving you that many continuances. This case needs to be tried. Hurry up, get this case done. And I think it's just not really fair.
Well, I think it's also really unfair that I feel like no matter what, without a removal of this judge, and in my personal opinion, it should have a special prosecutor. But once again, neither here nor there. My opinion doesn't really count for the court of Indiana. But the families are going to go through such an appeal process now, even more so than they would if it was just straight and narrow. He gets found guilty, we're done. He appeals. It kind of just goes through the process. Now they're going to have to actually be concerned that there's a better chance that they're going to have to go through another trial.
Right. 100%. And somebody told me to loosen my tie. I agree. It's been a long day. I've been working all day. It's like 6:50 Colorado time. I'm sorry if I still look very professional and formal. I've been talking all day.
No, it's okay. I'm just gonna I'll let them ask you these last few questions, and I'll let you go. I can just keep you. So I mean, you can just keep asking questions. What type of questions would you ask a juror in this case?
One, do they know anything? I mean, the biggest thing in a jury like this, or a case like this, is how many people believe that just because he's sitting next to me or sitting at the defense table, believe that he's guilty. Like, regardless of what you hear, where there's smoke, there's fire. He's sitting here. He's been charged with murder. The weight of the state and the weight of their investigation has brought him here. How many people believe that he's guilty just because he's sitting here? You're going to get a lot of people that are going to raise their hands. Second, in a case that's so publicized like this, you really want to get into what they know, what they believe, what they've listened to, what they've heard. In a case like this, you want really open-minded people that are willing to listen to the evidence, people that have not made up their mind, people that are willing to be fair, people that are willing to entertain that law enforcement could be wrong. Colorado Springs is very pro-law enforcement, pro-military community in Colorado. And so when we're picking a jury here, we've got to be cognizant of the fact that a lot of people have ties to law enforcement, and they don't like to think that law enforcement could be wrong. So it's kind of threading that needle between law enforcement can think that they have it right, but not necessarily be right, instead of saying that they're just 100% wrong, they lied, they misled you. And that's the difficult thing, is that you've got to thread the needle. You've got to get rid of all the people that are like, I'm 100% guilty because he's sitting there. Or you've got to get rid of people that are going to be swayed emotionally. This is going to be a difficult trial. We've got, ultimately, and we haven't spent a lot of time talking about this, but we've got two beautiful girls that were murdered, that were taken far too early, that at 13 or 14 should have had, 80, 90 years ahead of them to do who knows what. And so a lot of people have kids, or they have strong emotions. I always say that as a defense attorney, that I would probably be like the worst juror, because I think about a case like this and I think I could never be a juror in a case like this. I could never be a juror in a case that involves anything against children or animals or pets or anything like that. And so you've got to make sure that people are strong constitutionalists, that they believe in the Constitution, that they believe in his right to a fair defense, that they're disgusted by any procedural issues that may have kept him in custody for so long, that they're disgusted by the fact that the police chose him as compared to investigating other suspects or alternate suspects. That's kind of the long way of saying that that's kind of the way that I would push it. Everybody's different. Every defense attorney has their little ticks in terms of what they ask or what they want, but that's who I would want on a case like this. And the Eclipse Truth says, seems like victims are always lost in these cases, and that's 100% right. Like, the difficult thing and what all this conflict has created is that we're taking the attention away from two beautiful girls that were murdered, and really the justice system should be justice for them. It should be certainly justice for Richard Allen if he has truly been wrongfully accused or if he's wrongfully convicted, But a lot of times we lose focus and we lose attention off of, you know, the hurt that was caused to these families. And we have to remember that there's pain on both sides, whether we like it or not. Richard's family, you know, whether it's coping or whether or not they truly believe it's innocent, they're devastated. And in her family, devastation by 100. And so all these families are being ripped apart. You know, they're going to have to go through a difficult trial. A lot of times people frown on guilty pleas, but a lot of times in a case like this, families are potentially pushing for guilty pleas because they don't want to sit there and relive the events that happened. They don't want to see the photos. They don't want to see the videos. They don't want to sit there and worry that the jury might maybe got it wrong.
That's so tough though, because there's just there's so many victims that are just lost because we're here talking about just the judge and the defense attorneys and the prosecutor. But I try to tell people, like, it's the long term though, because if you want any like solace for the families in this, the longer this is dragged out and the more mistakes that are made, the longer it will be dragged out. Right. You're not getting justice for anybody, and the families are the ones who are ultimately suffering if this right. isn't done correctly. Okay, so I have to ask the big question of what would you do if you were Richard Allen's defense attorney, number one, and then number two, if you were the defense attorneys that just got removed, what would your avenue of recourse be? So first, what would you do as his attorney? Just thoughts.
I mean, it's difficult because there's so much discovery that we don't know and so much that we'll probably never know until the trial happens. And so the biggest thing is weeks and weeks and weeks of review, running it by people that also review it with me, hiring experts and figuring out their opinions. A lot of times we like to bring in like mock jurors and see what plays well and what doesn't play well. I think the other human component of this is that the new attorneys, or if I was the new attorney, you've got to spend a lot of time getting to know Richard and getting to know what type of a person he is, his feelings on the case, his relationship with his prior attorneys, and his relationship with me. I can only think of a few cases that I've tried to a jury where I haven't had some sort of a human connection with the client. And, you know, we can all, I'm not going to come out and say that the people I didn't are terrible, but, you know, we can all assume why I wouldn't be able to connect with some clients. But you have to have a connection and you have to figure out what they want to do and what their goals are. And are his goals that he wants a trial and he wants to run this defense, and can we figure out if this defense works? On the flip side, those attorneys that are off, it's difficult because we don't know why they got off. And if I'm that attorney, I'm trying to salvage my reputation. I'm trying to make sure that my client's rights are covered. I mean, the good thing here is that Richard's not going some long period without or being in limbo and not having any attorneys. But the bad part is that you devoted a big portion of your life. And again, I talked about a case where I got taken off 2 weeks before trial because of a conflict that I did not create. And that was devastating. Like, you spend a ton of time, you get to know the person's family, you get to know the case, you feel like you're the best person for the case. You're all set for trial, you rearrange your life, you get the hotel, you start rearranging your other cases. You bank on the fact that you're going to have this big trial and that you feel like you're the best person for it. And then all of a sudden, somebody else gets put on the case and it gets continued, and you never see or hear or talk to the client ever again, right? It's not like you can just call them at the jail. That would be a breach to talk to them at the jail or to talk to them once you're off the case. And so, you know, again, you know, it's difficult to say. Love to Hunt says, do you lock up your files away from wandering eyes? Yeah, I mean, all the offices I've worked at in the public defender's office have a very strict file retention policy, have very strict security protocols. You know, if I ever had a laptop that was stolen, first of all, they're very encrypted. They have a lot of security, but certainly break-ins happen at law firms. I've never been a part of anything like that. I've never had any leaks. You know, normally people sign agreements and sign contracts when they start with a firm, when they start with the public defender's office. And you hope that your team is trustworthy, and you hope that your team understands how inappropriate that would be, and that it would potentially lead to criminal charges, and it could potentially lead to an ethics violation or criminal charges against the attorney. Because frankly, anybody that's working for me, you know, if they're not covered by attorney-client privilege or if they're not covered by the rules, I am, because I'm supervising them. So if a paralegal were to steal, or if a paralegal were to take photos or evidence and try to leak it, I could potentially be in trouble for not having security protocols or anything like that. Just a quick sidebar, completely C-Dub. It's good to see you again. I know that we haven't talked for a long time, but did I follow the Riley White Claw case? Not really, just a little bit, because that Walgreens is right over by where my sister lives. And so a lot of times when I would go visit my younger sister, I would stop at that Walgreens. And so that kind of whole thing freaked me out. I really didn't follow that trial because it felt like it was too close to home. But that was a pretty high profile case that the public defender here in Colorado just tried. Love to Hunt wants to know further, do my friends know? I mean, I don't, my friends, a lot of the people in my life probably have no idea, unless they watch this YouTube channel, what I really do. You really don't talk about your cases. They're not coming in here looking at the evidence. You're not showing them your office, or like unless they're coming in for attorney-client type stuff. And so, again, those questions to me seem so ridiculous, but it certainly happens, and it happened in this case. And I can't speak for how that happened or how the defense attorneys allowed it to be happen.
Do you believe that by that happening, it would be considered gross negligence?
I think ethically that attorney is probably in a little bit of trouble because of the fact that he's allowed such a lack of security or a lack of awareness. I mean, ultimately, you're responsible for your employees. You're responsible for evidence retention. You're responsible to make sure that all your computers have, privacy filters and everything like that on them. And so it's difficult. I don't know, and we may not know. Like, this is just kind of an insight into the attorney discipline project, or attorney discipline system, but it's all confidential until they make a ruling. So there very well could be an attorney discipline action that's either pending or being investigated, but we won't know unless there's either a public reprimand or some sort of suspension or something to that effect that comes from that. So it very well could be that there is an investigation right now that's all subject to privacy laws, where something could be happening in the background.
Really? So I've sat here and we've talked about that. Why isn't there anything filed with the disciplinary board about this leak? Like, if she thought this was so grossly negligent, wouldn't it be her responsibility to file something? And we're like, nothing's filed, but we wouldn't know. No. In general, the attorney discipline system is all private and confidential because they could do a private reprimand. They could privately say this was wrong and you need a new file retention system, or they could publicly reprimand, which would mean that filing and that case would be open to the public. They could do some sort of public suspension. And so, again, it's a really difficult situation because, we're all humans. We like to think we're perfect. We like to think that the people we work for are trustworthy, but in a certain situation, I mean, it's just difficult because I think about all the security procedures that take place in order to get on somebody's laptop. But then sometimes you need to print stuff off, and sometimes you need, exhibits made and stuff like that. And you hope that you trust your law firm employees. You hope that you trust people that work for the public defender system. And, again, how can you be sure about everybody that you work with? And we've heard from this attorney that says, I had nothing to do with this, and this had nothing to do with me. And you kind of feel for both sides. You kind of feel for him, and then you also kind of feel for, anybody that is subject to this leak, because it's damning and it's terrible. And in cases like these, you hope that until the case is over, or maybe never, that crime scene photos are never released, that the family doesn't have to deal with that they don't have to see anything. And then you think about how much it could compromise a case because of the fact that potential jurors could see it, because stuff could be leaked that may not be even admissible in the actual trial. And that's a difficult thing when things like the press, they cover evidence that then later is inadmissible, have potential jurors heard stuff that they wouldn't. That's fair. Okay. I guess that's a great point. For me, I always kind of just feel like, as much as I know people don't want autopsy photos or crime scene photos, especially of children out there, and as a mom, I wouldn't want that out there of my kids. but it's not like anybody tampered with evidence. It's not like there's evidence that's out there missing. It's a photo of a photo that's sent out to the world. How does it truly impact the case? I mean, like, how is it grossly negligent when it's not, the photos aren't like missing, you know what I mean? Like, he didn't go in and take the photos and now there's no access to these photos type of thing. Does that make sense?
Let me tell you too.
There's
So if I'm going to put on the prosecutor hat for a second.
Okay.
One is, let's say those photos are leaked, and let's say somebody comes forward and confesses and says, you know, I did this, and this is how I posed the bodies, or this is how the blood splatter happened. Then law enforcement's in a pickle, because did they see the photos? Are they confessing because of the information that they learned in the media? And that's why often in these cases, law enforcement, even until the end of trial, keeps the investigation so close to hand, because they don't want false confessions. They don't want people coming forward saying they did it. The second thing is just the potential of the fact that some of these photos could not be admissible at trial for whatever reason. A lot of times crime scene photos are litigated pre-trial to figure out, what can and again, Love to Hunt says it's under a gag order. And I think somebody said that earlier. And that's something that I forget again. I don't know this case probably half as well as a lot of the people in the comments. So again, the gag order is big. And the reason a gag order is in place is for jury impartiality, so you can get a fair jury, so that there are stuff that's not pre-litigated. But in terms of the photos, where my original thought was going is that I litigate the photos ahead of time. And what I want is photos that are fair and accurate, but not over the top gory, that aren't going to prejudice the jury. You don't want to lose the jury, not because the facts are on the state side, but because the photos are so gory. And we've kind of talked about that before. When you're on a jury and you have to be subjected to this stuff, or the victim's family, some of those photos may not have been deemed to be admissible by the judge. But if they're leaked to the public, if the public has it, everybody's seen it, and everybody may make up their mind based on the photos. And so those are kind of the two things that I think are covered under that gag order, that would prevent false confessions, that would prevent potential jurors from finding out information about the case that otherwise isn't going to be made public, or otherwise hasn't been litigated yet.
Okay, that's fair. I mean, it goes against what I was originally thinking, because I'm like, this is not that big of a deal, as in, like, it's like the DNA is out there, or, you know what I mean? Like, somebody's profiles are out there or something along those lines. It's not tangible. It's not the murder weapon. So, okay. So now, before we wrap up, this will be the last question. Sorry, guys. I know I would just keep Chris too. So I know you guys in chat are gonna be like, no, we have more questions. What happens now? What are the options that Baldwin and Rosie have to get back in the case? What can they do?
I think at this point they're off, unless the Supreme Court comes in and replaces the judge and reverses some of her rulings. I think those two attorneys are probably off at this point. And I think the further away we get from that ruling, these two new attorneys are going to have to start working on the case. And it's difficult. They have no association with this case so far. They've been taken off. But yeah, my King of Kings, get the judge removed, and then maybe some of the rulings could be relitigated. Otherwise, I think at this point, the way that I foresee this going is that those attorneys are off. We're going to see new attorneys. The other difficult thing is that the court date has already been moved, and the judge has already made a ruling about the court date being moved. And so the court calendar is filling up, the attorneys' calendars are filling up, people are booking over those dates. And so it's not as easy as just bringing that court date back and then having these two attorneys jump back in. I think we're already going to see a delay regardless, because again, life is fluid, and the minute we lose that date, we have to replace it with other in custody cases. We have to replace it with civil cases. The jurors or the attorneys get busy. The cops might book other things. And so, those are all, they're just going to be difficult things that will happen. How does she know that the trial will only take 2 weeks? I don't know. That, to me, a murder case taking 2 weeks seems short. I think that this case will probably take longer, but who knows? We'll know closer when we're closer to trial and both sides potentially file their expected witness lists. We'll know how long potentially the trial will last. I think 2 weeks sounds really short to me. I can't imagine doing a murder trial in 2 weeks, but who knows? Things may be very different in Indiana.
Okay, so how does the Supreme Court come in though? Like, what does the attorneys have to do? Because right now that filing that's with the Supreme Court, like I was saying, is strictly really about her not really following the, leaving the court records and stuff like that up.
Mhm.
Do you think that, you think they're going to use that to try to have her removed? And then they can come back in and like they think the Supreme Court will take a look at all the things that were removed. They'll be like, oh, well, hey, what's this? Hey, what's that? And they'll look at those things, or do they need to file and do something else to get the Supreme Court to say, no, this lady's got to go?
I mean, I think that the Supreme Court will look at all her rulings, and they can potentially do what's called an interlocutory appeal, which is like a civil or criminal way to say that this case should be stayed while her rulings, which are potentially final rulings, are ruled upon by the Supreme Court. That's what I potentially see happening. I don't know the process in Indiana in terms of how they do that or in terms of what they do. I think a lot of this is to preserve the record for appeal. And in DC Primetime, before you came in, we talked about the fact that, to play devil's advocate for the judge, I would argue that if she doesn't take these attorneys off the case, if he loses at trial, the first thing that he's going to do is flip on his attorneys and say they did a crap job because they were conflicted off. They did things I didn't want them to do. They leaked evidence. They did this and that. And I think that she's got to be concerned. She's got to weigh the fact that this could potentially lead to a new trial after conviction with, the right to have him have his attorneys of choice. And she made the determination that it's better for appeal to take off the attorneys, give them a fresh set of unconflicted attorneys that don't have issues with the leak, that don't have issues that she believes that they may have. Let them try a clean case, let them try a clean trial, and either he gets found not guilty and the case is over, or he gets convicted and then he can litigate all this stuff. But at least then she's kind of cured whatever conflict she believes by giving him these fresh attorneys that are not conflicted off.
Okay, so now this is just going to be purely your opinion. Would it not be more beneficial for the case to keep his Sixth Amendment right to his counsel of choice and remove a judge than to have this same judge making the rulings on these attorneys saying that there's too much conflict and you got to go? Like, wouldn't it be better for Richard Allen for a new judge just to come in and make these decisions?
Yeah. I mean, I think I agree with kind of what was said before. I think the best case scenario in this would have been to have another judge hear the conflict and then another judge to make determinations about whether the attorney stayed on or not. I think what this gives the public, just in terms of my own commentary, just as a member of the public and not a licensed attorney in Indiana, is that it looks like something shady happened. It looks like what somebody just recently said in the chat, now I lost it, that the fix is in. And so, again, it's frustrating because we wish there would have been some sort of record made. We wish there would have been some sort of hearing to determine what actually the conflict was. And we wish that another judge would have heard it so that they would have been a little bit less impartial. We don't know, whether personalities come into play. Ms. Kay says it's shady. I agree. Like it looks to the member of a public, it looks shady. And so who knows, who knows why she's doing this. But again, it would have looked a whole lot less shady if another judge would have came in, if another judge would have had a fresh set of eyes on it and said, there is a conflict. I'm going to appoint conflict-free counsel and put it forward.
I agree. I just hope I hope it's not too late. Because like I said, I just feel like no matter what decision she made at this point, whether we're pro-prosecution, pro-defense, no matter what, I just feel like we're just setting ourselves up for appeals no matter what we do, because she shouldn't be the one making those decisions necessarily at this point, because the decisions are against her. But legally, I guess that's just how it goes. And it just is what it is. And then we just have to wait and see.
I mean, this is going to be the defense attorney, so don't everybody hate me in the chat. But if he's found not guilty, none of the appeals will happen. So it's interesting.
Well, yeah.
Because, if he's found not guilty, it's over. If he's found guilty, this is going to drag on for years and years and years, and years and years and years. And, Kelt just says, imagine if you're innocent having to sit in prison for years, I'd go insane or insaner. And you're 100% right. And I love that picture of the dog. It's difficult, and that's why it's just such a long process. And so I don't know. Journey takes a trip. Is it so the judge is Facebook friends with these? I mean, I keep learning these facts again.
Oh yeah, we didn't even get to that.
That's
So
weird.
the judge has 2 Facebooks. Her old Facebook that she doesn't use anymore is friends with one of the attorneys. That's one, and that guy, that attorney is friends with a ton of the judges in the area. So that's one issue. And I guess I should have asked you this earlier too, because I totally forgot this. The other attorney did an interview when the probable cause affidavit came out, essentially stating that the state had really good evidence against him.
Yeah.
And now
I mean,
this guy
for
is
that,
representing.
I'm gonna send you guys down a Google rabbit hole tonight.
Okay, do it.
One of the things you should look at, I can't remember what the girl's name was, but there was a beautiful young girl killed in Iowa a few years ago. I think I was in Colorado by that point, but she was a University of Iowa student, and she was killed jogging. I think it was the Molly Tibbetts case. And Molly Tibbetts had some crazy court-appointed attorney to begin with, and he was saying all kinds of crazy things to the court. And then he ended up hiring an attorney, and it was a couple, and that couple had gone on the news talking about how guilty their client was before they took the case. Like, they were like, he's guilty and the evidence is so strong. And I think they let that couple stay on the case. And I think at that point I was a public defender, maybe in Colorado, and I was thinking that seems like a clear conflict. He's put out there to the public, and he's made all these, extrajudicial statements saying how guilty his client is, and now he's representing the client. But apparently that's not enough to get somebody disqualified from the case. Now, being Facebook friends with a judge, to me, is, again, I'm not an Indiana attorney, but to me it seems like it shady, unethical, not something that I would do. I certainly have a big social media, and I'm not friends with any judges. And you run into problems when you're friends with judges, because then you can't appear in their courtroom. And I think, to me, that's probably the worst thing that I've heard. That's not something I was familiar with until it came up in the comments. And again, kind of knowing how the judicial system works, I wouldn't hold my breath that that's going to be something that disqualifies those attorneys. But
That's what Shane just did too.
Shane is reading my mind, or maybe I saw that out of the corner of my eye. But again, I don't know. I don't want to just jump to conclusions. I probably need to do some more research. But I think that there's a lot of things here that people are getting a good eye for, that that our justice system is potentially broken, especially in smaller communities, especially in smaller states. But that, putting a public eye and making some of these trials public and streaming them on WebEx and Zoom and Court TV and all that stuff, hopefully it brings more attention to potentially some of the shadiness. But when
I don't know if she's going to allow cameras now, though.
Yeah, and it's hard to say. I don't know what the Indiana rules are. I don't know what the Indiana Supreme Court rules are on pretrial publicity, but most states after COVID allowed for live streaming because people couldn't attend court because of illness or the risk of illness, or they didn't want to travel. And so it's just crazy. C. King says the lawyers she placed with them are her personal Facebook friends. I mean, that's weird. That's, I don't know. I don't even know what to say about that other than it's weird.
So she like basically essentially handpicks these people. And the one that's friends with her actually just got off of a disciplinary action last year. It's not public on why. And he is the head of the public defender's office, but they're from Allen County, which is also another interesting point because her daughter is a prosecutor in Allen County. So they're all kind of weaved together. So now we have the veneer from Allen County. We have a judge that's been pulled from Allen County. And now we have the public defender, the appointed public defenders pulled from Allen County, and the prosecutors from Carroll County.
Yeah. I mean, let me really put it out there. What if the judge, or what if not this judge, but any judge, I mean, the error in her being allowed to pick who she wants is that that's kind of why we have a public defender system in other states, because like in Colorado or Iowa or other states, is because, yeah, it's like Jeremiah M says, cronyism to an extreme. Like, what if she's only picking attorneys that she know are not going to litigate on behalf of their clients, are not going to, do something like that? That's just, I don't know. To me, it's just, it doesn't feel right.
Oh goodness, yeah. The judge's daughter is a prosecutor in the same kind. Yeah, that's what we were just talking about. You stated now you. I don't even. I'm not sure what's going on, Miss K, but I don't know which one you're talking to. Can anyone confirm Ramirez? I don't know. I'm trying to make sure we didn't have any other pending questions for you. I am just so thankful that you came on. I've kept you for over 2 hours. I'm so sorry.
That's all right.
Is it her first death penalty case? I don't even think they've actually said they're going for the death penalty at this point, because those new public defenders are not death penalty qualified.
And Ruckus Rocks wants to know, tell everyone how a public defender gets paid. They get paid by the state. So you get paid by the state. It's a separate entity. So a lot of times people are always like, oh, public defenders are disqualified, or that they have a benefit. I think public defenders in Indiana are separate, though. And what I looked at before today is that they're actually private attorneys that have a contract with the state, as compared to like a state system. Like Colorado has a state system where all the public defenders are paid by the state. The district attorneys here are paid by the county. And so it's a different, they're paid by taxpayers. And, again, I'm not going to go on a long tangent about why taxpayers pay for public defenders, but it's a lot of times for cases like this where, you want a constitutional defense so that this case doesn't stretch for years and years and years. You want to make sure people are qualified. You want to make sure they're taking courses. You want to make sure that they have insurance. You want to make sure that, Jeannie Smith says that these new attorneys get paid by Allen County.
They're going to get paid by Carroll County.
Yeah.
Aren't they? Yeah. I mean, that because the crime is out of Carroll County, the cost all has to come out of Carroll County.
Yeah. Mm-hmm.
And I totally had a thought that I was going to ask you something, and she actually asked the prosecution, what do they think about the defense? Okay, so that's another question. I've got to let you go, though. I'm like I said, I could just keep going all night long. How does the prosecutor get to say, hey, we would like to request that these guys get kicked off the case for gross negligence? Does the prosecutor have the right to do that?
No, not usually. I mean, prosecutor usually doesn't have a say in terms of whether or not it's a conflict. It's usually the judges. And so, that's kind of where it's at. I've never seen a prosecutor, unless there's an actual conflict and the prosecutor is raising the conflict, like a public defender or a private attorney is representing both or two witnesses that are potentially conflicted. That's when I've seen prosecutors say there's a conflict, like, judge, this defense attorney is representing two people that are adverse to each other, but not in this case.
Well, what do you think about the fact that now you have these pro bono attorneys that are going to do it, and it's not going to cost the taxpayers $1?
I mean, if I was a taxpayer in that county, I would be saying great. And, again, they were caught up to speed. It's going to cost the taxpayers a lot more money to have these new attorneys sift through mounds of discovery, get caught up, have to look at the videos, have to decide what they're going to file. And so if I was a taxpayer, I'd probably be writing a letter to the editor tomorrow that says, let's let these guys do it for pro bono. But again, we have to ultimately hope that the judge is doing things to protect the record for appeal, and that she's doing things to not prolong this. 4 Pit Bulls Across America says Judge Gull has a 1.7 review. I don't know what that means, if it's like Google reviews, but that doesn't sound very good. I don't know anything about this judge. I haven't done enough research to know whether or not, what her reviews are, how they review judges in Indiana. Again, I'm a Colorado attorney. So that's it. I don't know. Does anybody else have any other questions before?
Well, they're going to keep you going all night. So, but Chris, I just want to thank you.
Well, again, and I'll look for questions right now, but it's been my pleasure to come and come back. For some of you, I've seen you before in other cases. For some of you, I haven't. Again, I don't pretend to know anything. I don't pretend to have a feeling about whether or not he's guilty or innocent, because I honestly don't know. And I haven't seen the evidence. And, So Marshall, you're still filed up. I'll probably be fired up when I get home and not sleep. So I'll probably be tired tomorrow. But again, I think it's so important that we shine a light on these big cases, that we stay involved, that we draw attention to the judicial system. Again, this is a case that's for justice. And, whether or not you believe that he's 100% innocent or whether or not you believe he's 100% guilty, you hope that justice will swoop in and that the right outcome will happen. And you hope that this case will have some finality for the family, or you hope that the case will have some finality for Richard Allen and his family. And that's all we can hope. But I think that when YouTube and podcasts shine a light on the criminal justice system, people get involved, they ask for law changes, people go to law school, people get more involved and know more about the legal process. I'm always impressed when I come on these channels how much people know. And so again, thank you so much for having me. If you are ever in Colorado and you need an attorney, even if it's, again, I used to say if it's for criminal defense, and then people would be like, well, I'm never going to get in trouble. And, ever since I left the public defender's office, I've been able to do all different types of criminal defense cases. So I've always told people, if you get a speeding ticket or something like that, call me. But now it's good because we're doing personal injury. You can look up the Bussey Law Firm. Tim is a great guy that's done a lot to bring down corruption in Colorado. He shut down some of the state labs that were doing unethical things on DUI stuff. He's really been amongst the forefront of changing a lot of the laws to make them so that justice is served. He was a longtime district attorney here in Colorado. He was an Air Force JAG, and that's how he ended up getting here. And so I think that I've landed on my feet again here at a great firm. That's why I came over from the last firm that I was at, because I wanted to learn more. And, I enjoy speaking. I enjoy being in court. And so thank you so much for having me. I don't really see any other questions or anything like that. Somebody did tell me to loosen my tie when I go home. When I'm not at work, I hate wearing suits. Like if you follow me on social media, I'm pretty much always on a mountain bike or out hiking if I'm not here. So people don't even recognize me when I'm not at work. So
That's so
I will go and get my dog out for a run or do something like that tonight. If anybody has any questions, or if I forgot anything, or if you have any comments, or you think that there's something that I should do different, feel free to email me. Feel free to call. Allie Cattail says, what's the firm? It's the Bussey Law Firm. If you look up on Google, I just started in the last few weeks. I was with Clifton Black here, and I was the manager of the criminal defense section for the last few years. I don't think I'm even on the website here yet, but you can look up Tim Bussey, and I think we'll have me add to the website in the next few weeks. We're doing some marketing in the next few months or so. Again, any type of criminal defense case, any type of personal injury case. Anon, love the suit. Thank you. I don't love suits again, so it's hard for me to take that compliment because I'll be out of here as soon as I can. Thank you again.
I think everybody is very appreciative of you.
Yeah.
And we would love to have you come back. I mean, and the way that this case goes, there'll be 30,000 filings by the time that we get to see you again, and nobody will be able to keep up.
I know. It's like when I did a deep dive, when Jennifer hit me up and said that she wanted me to come on and talk about this case, I did a deep dive, and I can't believe DC Primetime. Yeah, it's Tim Bussey or Timothy Bussey on Google. And feel free to leave a review or anything like that. That always helps. Our business kind of thrives on 5-star reviews. But when she told me to come on and talk about this case, I had listened to podcasts years ago. Like I remember listening to, I think it was called Down the Hill. When I hike, I do a lot of podcast type stuff. And I remember listening to a podcast and then I kind of forgot about it. And then in the last few months, it's been all over the national news. So then I really went down and did a deep dive. And this case, I can't believe, it's shocking. It's just, I mean, you could spend hours and hours and hours. And last night I was trying to stream as much as I could on podcast while doing other stuff. And it just was crazy. Dark Horse Justice, let me just look up. I tried to type into the chat, but because I'm on StreamYard, I couldn't. Let me just look up and see the spelling of our website. It is the Bussey Law Firm. So it is THEBUSSEY lawfirm.com. And again, we're in Colorado. We're in Colorado Springs, but we do most of Colorado. If there is like a personal injury case, I'm licensed in Iowa. Tim's licensed in Illinois. We do go to other states to do that kind of stuff. So if someone is injured or killed or something to that effect, then we would represent them in other states. But I would love to hear from people, and hopefully I can come back.
Digital said 30,000 filings, none of which will be on the court records. All right. Well, thank you so much, Chris. I appreciate it, and I hope that you do come back.
All right. We'll see you guys later. Good night.
Night. Oh my goodness, you guys, I am so thankful that he took the time out of his day, and I know he already worked today, and then he still stayed and hung out with us. I'm so thankful. It helped me process some of the things that I'm like, because I'm not a lawyer, I just play one on YouTube sometimes. No, I really don't, because I don't. I know some things about the law, but I've never practiced it. So it was amazing that he was able to answer questions. He put a lot of things in perspective for me, which I'm very thankful for. He did a lot of work with Crime Curious on the Letitia Stout case and helped us kind of navigate through that too. So he's just a kind, good guy and loves his dog too. So that makes him even better in my book. But I appreciate all of you guys hanging out here with me tonight, and asking questions and staying so respectful and just kind. I love it. I appreciate each of you. And I know you guys have 1,000 other places that you could be, and you choose to be here hanging out with me. It was probably because of Chris and Crime Curious, but I'll take the win. But I appreciate each and every one of you. So go and enjoy the rest of your Wednesday night, Thursday early-ish. If you're on the replay crew, I appreciate you guys too. Don't think I don't. I will tomorrow. I think I will be back tomorrow. Yes, I should be back tomorrow. What we're going to be talking about, I have no freaking idea, but we'll figure it out. Have a good one.